Hey, oh my God, we're back. What a morning. What did we watch this morning? We are back with the proceedings. The judge is back and she's absolutely on time. We're 2 minutes after, so we're going to jump back in. Quick recap for those that are just joining us for the day. We've been streaming since about 9 a.m. this morning. We saw John Melnick take the stand. We saw Kayla Bumpus take the stand as well. From what it seems like she was unexpected to take the stand, but she took it anyway, right? She did go live a little while ago. So shout out to all the people that let us know that she went live. I did pop in to listen to what was happening. Y'all don't want to see Dennis Byron's Twitter. Please don't go over there. I'm saying that in a good way. Now, again, I have a lot of respect for Kayla. She said she was not nervous. There were some other things that kind of came up. She does not care what people are saying about her. Again, from creator to creator, I don't like to down other creators, but if y'all really want what I think one of my favorite meme videos can describe it. Let's watch what I thought of this morning's dumpster fire. These were AV's thoughts.
Bad day that just turned into a good one. 74-year-old hitchhiker has been found alive after being struck by lightning, attacked by a grizzly bear, attacked by a pack of raccoons, and bit by a rattlesnake. She's going to be just fine. We are getting breaking news, though. The mechanics on this helicopter, we are having some issues. What is going on here, guys? Get her in there, for God's sake. We are live in Sky Fox 1, and this situation has taken a turn for the worst. I don't know if the pilot went out last night or what's going on. This poor girl is trying to be rescued. Little did she know she's signing up to train to go to the fucking moon. Wow, I feel like this is a scene out of Apollo 13. This is not good at all. She is spinning uncontrollably. I mean, this is like the zipper at the carnival. It is safe to say, Peter, this girl is going to be very dizzy. She's had a bad day, and look at this. The pilots are just going to say, fuck it, and they're going to just drag her along.
That is what I think, if you want my opinion, okay? So let's get back to the trial and resume what we were doing. I love Bob Mannery. I love his sports announcer voice. That will always be a classic to me. But if you want my opinion without me telling you my opinion, that is my opinion. Let us begin.
It's not anything of substance that is important. I want everybody to speak into your mic, and let's make sure each of them works all not at the same time, one at a time. And if there are any that don't work, I'm going to try to see if we can get a hold of one that does. So can we start with the state?
Yes, Sean.
All right. And I also am going to try to get a longer neck on each of these, which might help. But for the meantime, let's just see if it works at all. Mr. Weinstein.
Good afternoon, Your Honor.
Does that help at all? Did y'all? I don't know that yours works. Pull it towards
Can
you.
y'all hit the like button for me as we get started? We're 3 minutes in. Hit the like button.
Good afternoon.
All right. Yeah, you're just going to have to get it closer.
User error, I think, on my part.
User error. Okay.
Good afternoon, Your Honor.
Okay. Mr. Steele, does yours work?
Your Honor, is that helpful?
I think we've all got to get closer to them. And I can hear, but I've heard that other people can't hear. So
Is that okay?
that's great. Mr. Schardt.
Testing, Your Honor.
Great. And then who else is left? Misty Williams.
Good afternoon, Your Honor.
All right. Wonderful.
Good afternoon, Your Honor.
Awesome. Thank you. Okay. All right. And now we have somebody here for everybody as well. So let me cross-check marks off my list. Okay. Ms. Love, was there any evidence you wanted to present or any witness you wanted to call with regard to our morning proceedings?
Your Honor, given the
Oh my God. I'm sorry. Stop the show. Guys, Thugger Daily just tweeted out, you know who's talking about this case? Donald Trump is on talking right now saying that Young Thug is being treated unfairly. by the same prosecution's office that is trying him for the same charge, for not the same charge, but a similar charge for RICO charge. Today should just go in the trash. I mean, oh my God. Oh my God.
The scope of what the court has already told us that we were looking into, I don't have any witnesses based on Ms. Bumpus's testimony. And my understanding is that it was Brady material disclosed during the June 10th, 2024 hearing in chambers.
Correct. And what she alleges was disclosed is that Mr. Copeland said, I know more about the infinity, and it has to do with somebody that's not on trial. I'm paraphrasing, but.
And so the fact that,
Hang on a second.
yes,
Yes, sir, Mr. Weinstein, you
I'm
think
sorry.
there's more to it?
I didn't mean to give you side eye, Your Honor.
Oh,
yeah, I
did
do
does
believe
you?
there was more that she said that was disclosed other than just the infinity.
Okay, what else?
Specifically, when she said that the state would not prosecute Mr. Copeland for lying except for that one thing, which she said was the murder of Donovan Thomas. I believe that was on the redirect at the very end. With that,
Yeah.
that actually came through more clearly than I think anything else, Your Honor.
Okay,
Yeah.
so,
may I respond to that? So because that did not, in my mind, amount to Brady, if the court is inquiring into a different issue of.
hang on just a second. Everybody who's got a phone on you, make sure it is on silent. And you should only have a phone on you if you are an attorney or if you have a Rule 22 that permits you to have a phone. Anybody else in here should not have a phone on them at all. If you do, it should be turned completely off.
I'm sorry, Your Honor, that was my computer. I
Okay, it
apologize.
happened.
I
Oh, your
silenced it.
computer? Okay.
I silenced it.
All right, thank you. So, Ms. Love,
I was just saying that based on the parameters that the court set forth, my understanding was that anything that is alleged to have been said by Ms. Hilton in that regard does not impact whether or not Brady material was disclosed. And I'd have a different argument at the appropriate time that the court tells me is the right time to make it. But my position would be that given that defense attorneys came to Ms. Bumpus within an hour of the meeting before court went back in session and asked her, so they had information, they had, I assume, the content of whatever it is that
Y'all
they
give me a
are
like.
alleging took
Put
place.
my likes up, please.
And then Ms. Bumpus, based on what I heard her say, told them, sort of filled in the blanks, I'm using my words, not hers, and gave to them this information. My understanding of what Brady is that it is information that is not available to them by any other reasonable means. And they have, obviously, they had someone telling them something about what was going on. So it's not a Brady violation if they had access to it. If there's a different argument, a different issue that we're going to be arguing, I'll hear that from the court. But as to the Brady violation, my argument is that based on her testimony, there was no Brady violation.
Let me add this, Your Honor, too, if I may. Also, the testimony of Mr. in the off-the-record meeting where Mr. Copeland.
the alleged off-the-record meeting.
The alleged
Mhm.
off-the-record meeting with Mr. Copeland, to which Ms. Bumpus testified to, where Mr. Copeland allegedly said, I can claim all of this, I can take all of this over and over again. And the all of this was regarding the unliving, the murder of Donovan Thomas. I would submit that Mr. Copeland allegedly saying, I can claim all of this, I can take all of this would be Brady material.
And Your Honor, again, given that Ms. Bumpus is the person testifying about it today, and that Ms. Bumpus is the person that was approached by members of the defense within an hour of the meeting, that assertion made by her, though I don't agree with counsel's characterization of it, is information that is available to them. But more importantly, Your Honor, I asked Ms. Bumpus specifically what was asked right before. What she said, she understood it to mean Donovan Thomas. But I can claim all of this. My position is that it's not Brady. I can say I can claim it all too, but a hypothetical, I can. What you can do is not saying something that is.
All right, I understand your argument. So just for clarification, you said I had set parameters as to what is and isn't Brady, and
No.
I haven't set any parameters as to what is and isn't Brady. Brady is what Brady is.
I agree. No, I'm saying the parameters that I was speaking of was that you were talking about. This hearing is about whether Brady material was disclosed. And my position was that what Ms. Hilton is alleged by Ms. Bumpus to have said to Mr. Copeland would not, I don't think it would amount to Brady.
Guys, let me just say this for those that are coming in. I know we just got back from the lunch break. Your girl has been cooking all day. I'm really working hard today. The least you can do is if you hit the like button earlier, hit it again on your way in. It pushes it out to more people, lets everybody know that AV is live. I'm bringing you this heat. We are a little bit delayed. I like to do that because if there are any little moments in court where we can skip ahead, we can do that, right? So we did start early. We're supposed to start this stream at 2:10. I started a few minutes early. Do me a favor, hit that like button. I see you guys almost there. Half of the ratio. There's 1,400 people in here, 700 people in the chat. Lead was here earlier. He checked y'all. He told me to lock y'all out. And I haven't done that all day. Do me a favor. Catch up with those likes and we'll be good. Get me to 700. We're almost there. I just need 40. I won't hold your stream hostage though, but look at your comrades around you that are not hitting the button. Let's go.
But if it did, I can put up a witness about it. I just didn't think that it was necessary unless the court saw it differently than I did.
So I guess what I wanted to have us look into is whether what was alleged to have occurred, i.e. an off-the-record conversation that was between Ms. Bumpus, Mr. Copeland, and Ms. Hilton occurred, and then if so, what the substance of it was and whether it contained any Brady. So if you don't want to dispute whether it occurred, that's up to you. I'm not going to tell you how to run your case, but I think that's a part of the inquiry as well. So I don't want to mislead you about that. So if you have any evidence that you want to present to dispute whether it occurred or to give us some more, shed some more light on that subject, you're welcome to do that as well.
State calls Deputy Chief Investigator Antonio Long.
Or while Investigator Long is taking the witness stand, I am specifically objecting to the proffer of Ms. Love, always. But in addition, Ms. Love said that me and other people who represent people, God forbid, accused of these acts, knew already about the ex parte meeting and what occurred and the concern, and that is just false. That is just false. That was not testified to by Ms. Bumpus. What she said was they knew that a meeting occurred. No one said contents.
Actually, my recollection is that I asked her specifically that question. Did you share the off the record portions as well? And that she said, yes, she did.
I agree with that. Ms. Love said that before meeting with Ms. Bumpus, that me and other lawyers or people on the defense side knew about what was said at that hearing, and that did not happen.
That's totally irrelevant. So I appreciate it, but I wasn't even accepting that as any kind of a proffer of hers. But yes, so noted, and that's fine. Okay, was there anything else with regard to that? All right. So you said you weren't going to accept a proffer from Ms. Love, and that's fine. You said also Miss Long? Do you mean Investigator Long or Miss Hilton, or is there a Miss Long?
Spoke, Miss Love is who I meant, but I think because Investigator Long has taken the stand, my mind may have been,
All right.
been with him.
Okay. And with regard to just on that topic, the earlier proffer by Miss Love that you objected to, and you said on the record, I don't ever accept any proffer from her. And I said, that's up to the court. I meant it's up to the court whether I want to hear it or not. But with regard to that, and that was about Mr. Abate, my ruling with regard to that was that's not even relevant until such point as there might be some other defense motion filed, at which point Ms. Love can call Mr. Abate. So, okay, so call Investigator Long. Thank you.
Oh, we got a new witness, guys. This is witness number 3 for the day. This is an investigator from the DA's office. Let's go.
Antonio Long, Antonio, last name Long, Long.
And Your Honor, before I begin, I just wanted to point out that I'd like to just make the record. I know that everyone may be familiar with Deputy Chief Long, but I'd like to ask the preliminary questions that establish who he is and where he works, if with the court's permission.
Okay, that's fine, but he's not going to be testifying as an expert, so let's just, cut to the chase. To the extent he's not going to be testifying as an expert right now. He's going to be a fact witness.
Yes.
Okay.
Yes.
So maybe we don't need to go through all of his background. All right.
Just good afternoon, Deputy Chief Long. Would you tell the court for the record where it is that you work?
I work for the Fulton County District Attorney's Office.
In what capacity?
Deputy Chief Investigator.
As Deputy Chief Investigator, are you over any particular units?
I am.
All right. Are you over the unit that is prosecuting this case that we are here in trial on?
I am.
And as part of your responsibilities as Deputy Chief Investigator, do you accompany attorneys to meetings with witnesses or other attorneys?
Yes, I do.
Specifically, are you tasked with accompanying Deputy District Attorney Hilton and myself when the needs arise?
And among other attorneys, yes.
On June the 10th, 2024, do you recall that date?
I do.
And did you accompany myself or Ms. Hilton to the chambers of Chief Judge Glanville on that day?
I was with Ms. Hilton.
Was there anyone accompanying me? As
Yes.
investigator? And was that person one of the lieutenants with the DA's office?
That is correct.
While as Deputy Chief Investigator, do you give instruction to lieutenants and investigators regarding how they are to keep the lawyers in line and keep their eyes on the lawyers?
Yes, I do. I give guidance and counsel in reference to that.
And are you all required to remain with us at all times during those types of meetings?
Yes.
June 10th of 2024, do you recall who was present in the judge's chambers at the time you arrived with Ms. Hilton?
I do recall Judge being present, court reporter, Ms. Kayla Bumpus, several deputies, and with Kendra Copeland, and myself and Ms. Hilton.
Was I present in chambers at the time you arrived with Ms. Hilton?
Not when Copeland was there, no.
Did I ever come back after Copeland arrived in chambers?
You did not.
Did you remain with Ms. Hilton during the entire time that she remained in chambers?
I remained with her the entire time she was with Ms. Copeland.
Okay. Were you present with Ms. Hilton when was Ms. Bumpus in the room during the entire time that Ms. Hilton was in a room with Mr. Copeland?
Yes.
At any time did Ms. Bumpus leave the room and leave Ms. Hilton in the room with Mr. Copeland without his attorney?
No.
Were you present in the courtroom today when Ms. Bumpus testified?
I was.
Did you hear Ms. Bumpus talk about an off-the-record conversation that took place between Ms. Bumpus, Ms. Hilton, and Mr. Copeland?
I did.
Do you recall during the time that you were in chambers with Ms. Hilton, how many times, if any, that you all went off the record?
Make sure I understand your question. How many times do we go off the record?
Yes, and let me back up and ask you this. Were you able to discern when you all were off the record?
Yes.
How?
When the court reporter was not documenting what was being taking place.
Was there ever a time that you all went off the record at either attorney's request, that is either Ms. Bumpus or Ms. Hilton's?
From what I recall, there were times we stepped out of the room so that Ms. Kayla could talk to Mr. Copeland. And then the last time, there was a conversation before we went back on the record.
At any time that you all stepped out of the room so that Ms. Bumpus could speak with Mr. Copeland, did you observe me go into that room?
No.
Now, when you said there was a conversation that took place the last time, would you please tell the court what you're referring to?
The conversation I believe Ms. Bumpus is talking about right before we went back on the record. There was a conversation where Ms. Hilton spoke with Ms. Bumpus and Copeland before the judge and the court reporter went back on the record.
I agree,
Did
Esquire.
that
Her.
conversation take place
I like your
following
name.
the time when Ms. Hilton exited the room so that Ms. Bumpus could speak to Mr. Copeland? Or was that a time when you all were sitting in the room and you just went off the record?
That was a time where we took a break, and before we came back on break, it happened. If I'm answering your question, if I understand your question.
Did you all, you and Ms. Hilton, did you all leave the room when you say you took a break?
Yes, everybody left the room
Okay,
except for Mr. Copeland and the deputies.
okay. Did Ms. Hilton have any contact with Mr. Copeland during the time that Ms. Bumpus was not in the room?
No.
Were you present when, or do you have any memory of Mr. Copeland saying something akin to, "I can claim all of this"?
No.
Were you and Ms. Hilton within close proximity, within 2 feet of each other during the entire time that you all were in chambers?
Yes.
Are you able to say whether you all would have been privy to whatever was said? If she heard it, you would have heard it. If you heard it, she would have heard it.
Correct.
Do you recall speaking with Ms. Bumpus and Mr. Copeland about the Donovan Thomas murder?
No.
Generally speaking, starting there, would you tell the court what you recall talking about?
I'm unclear as to when you're talking about. Starting where?
During the time that you were in chambers with Ms. Bumpus, Mr. Copeland, and Ms. Hilton, can you tell the court the topics that you discussed, that not you, but Ms. Hilton and Ms. Bumpus and Mr. Copeland discussed?
The topic at that time, Ms. Hilton just made it clear to Mr. Copeland that she expected him to tell the truth, and that if he was going to get on the stand and claim something that he know he didn't do, then she would be looking at prosecuting him for perjury.
And so I'm clear, is this on the record or off the record that this conversation takes place?
This was off the record just before the judge came back in.
Have you had an opportunity to read the entire transcript of the in-chambers hearing?
I have not.
Do you recall Mr. Copeland making any direct statements about his involvement in the Donovan Thomas murder?
He never mentioned anything about involvement in Donovan Thomas murder.
Do you recall him making any indirect statements or statements that could be construed as an involvement in the Donovan Thomas murder?
No.
Did Ms. Hilton, during her conversations with Ms. Copeland, while you, Ms. Bumpus, Mr. Copeland, Ms. Hilton, the court reporter, not the court reporter and the judge, in other words, during an off-the-record conversation, did Ms. Hilton?
All right, hey, back up. So is it your testimony that there was one brief off the record time when Ms. Hilton, Ms. Bumpus, and Mr. Copeland were all in chambers, but before the judge was back in chambers? Or just tell me, maybe I'm yes, no?
Yes, we broke for someone used the restroom.
Okay.
And before we went back on the record, that's when Ms. Hilton and Kayla had the conversation before Ms. Weaver began to record everything.
So Ms. Weaver was sitting in there.
She was not in there at the time they were off the record.
Okay, well, I mean, you can be off the record and still have the court reporter sitting in there, so I'm just trying to
No, she
get
was not in there.
clarification. So this was after a bathroom break.
Right.
Ms. Hilton and Ms. Bumpus head back into chambers before the court reporter and the judge are back. Is that right?
Well, I won't say Ms. Weaver did come in.
Okay.
And then Ms. Simone Hilton did ask, she needed to say something with Kayla and Mr. Copeland before the judge came back on the record.
And Mr. Copeland's in there at that point in
Mr.
time?
Copeland was in there.
All right, and so what is the substance of that very 2-minute or whatever conversation?
It was Ms. Hilton explaining to Mr. Copeland that if he did get on the stand and take credit or tried to take credit for something he didn't do, she would then seek prosecution for perjury.
She would.
Seek prosecution for perjury.
And did she talk with any specificity about what crime or crimes that would include?
She did mention the Donovan Thomas case, and that if you got him claim something that he knows he didn't do, and we have proof that he didn't do, then she would prosecute for perjury.
All right, and so your recollection is that that conversation occurred off the record before the judge was in there?
Yes.
Okay. Do you have a recollection of a very similar conversation also occurring on the record?
No.
So if it's reflected on the record, then that's the conversation that occurred?
Say that one more time, Judge.
Were there two very similar conversations about that, where Ms. Hilton is saying, if you get up and say something that we know you didn't do, we're going to prosecute you for, or I'm going to prosecute you for perjury?
During the course of the conversation, Mr. Copeland's concern appeared to be his statement.
Is that somebody's phone?
Or inconsistent statements.
I'm talking about just the off the record now.
Is that a phone?
Just off the record was just in reference to him taking responsibility for something that he didn't do.
Okay. I have no idea why that phone is ringing or how to turn it off. This is not my courtroom, so we're just going to ignore it.
This day is a shit show. Guys, here's what they're talking about. And let me just give you context while we're trying to figure out why there's a phone in the courtroom and why the judge's phone is ringing while the trial is going on. Oh my God. So this is the Deputy Long, who works for the DA's office. He was tasked with being with Simone Hilton throughout the day. They have dangerous jobs. So this deputy it has been tasked with staying with her the whole day. We are recounting what happened on June 10th. Love is calling him as a witness. Of course, all 6 defense attorneys are going to have the opportunity to ask him questions directly. So we're going to see that in just a moment. I am running 5 minutes behind for the people that don't like that. I do that to save us time where there are dead moments or breaks. We can speed up faster and catch up. That's why that's being done. Now, the judge, I've been saying this all day. When the judge has to jump in and take over the questioning, it's because she's, number one, trying to understand what's going on. And number two, she's actually kind of stepping in as a lawyer, guys. I mean, Judge Whitaker is just like, okay, so is it your testimony? Because if you just said this a few minutes ago and it's contradictory to what we're asking you, it's not a good look. Because what we're really trying to get to the bottom of, there was a point, and if someone had asked, I started what Brady material is. Brady material, it's a case. We say that in law, but it's we call it Brady for short. But it is a case where Brady was one of the parties against, I think it's the state, or it might have been a federal case. But basically, it is the law of the land across the United States that if you have information or evidence that can exonerate a detective, and if you are a defendant, and if you are on the prosecution side, you must turn that over to the defense team. You have to do that to the defense team. You have to give it to them, because that exonerates their client. You can't hide the ball, basically. That's what that means. The reason why we're getting to this statement around Nut, Donovan Thomas, is because at one point, did Lil Woody say, I killed Nut? That sentence right there. He did not say those words. But what he did say was, I will admit to all of these crimes. But Lil Woody said that under pressure. When you use the word all, it's like a basket. A lot of things could fall into that basket, right? That's what we're trying to get to the bottom of here. All right. So we're going to go back. It looks like Judge Whitaker is trying to figure out this phone situation. I haven't heard that ringtone in such a while either, but let's keep going.
That phone being the desk phone on the bench for some reason. I don't know why. Okay. Sorry about that interruption. All right. And you only recall one conversation about that, whether it occurred on or off the record?
I only recall one conversation specifically in reference to Ms. Hilton saying that she would seek perjury unless it was something blatant, a blatant lie.
She would or she would not?
She would not, unless it was a blatant lie. She wasn't concerned about inconsistencies that she would use impeach. She would just impeach him for inconsistencies.
Okay. So do you recall any conversation where Ms. Hilton says, and this is on or off the record, Ms. Hilton essentially says, look, if you get up there and you claim something that you're the one that did something, and I flat out know you didn't do it, I'm not going to prosecute you for perjury for
Thanks,
that,
Marty.
because
That's
I don't know
okay,
what your
Seth.
reasons might be.
I don't recall a conversation to that. I do know that she used an example that she would have to corroborate something before she prosecute.
Okay. All right. So the extent of the off the record before the court got back in their conversation was her essentially just saying what?
Her conversation was in reference to him getting on the stand and taking responsibility for something that he know that he didn't do, or falsely admitting to something that he did after receiving use immunity.
All right. Go ahead, Ms. Love.
That's the other thing, guys. Thank you, Marty, for citing the actual case. This is a federal case, Brady v. Maryland, which went all the way up, I believe, to the Supreme Court. Guys, check this out. The other statement we need to analyze is this one. When Woody is on the stand and actually says, I did these crimes. So you have what he's saying ex parte, but you also have him admitting that he did the crimes. So I think this afternoon is actually going to be really interesting as we get to the bottom of these statements and how they relate to the case itself. Thanks again, Marty. Let's keep going. And shout out to all the attorneys in the chat. There's a few of y'all. I saw Keita in here. I saw a few of y'all popping in, and shout out to Marty as well. Let's keep going.
Thank you, Judge. Did Ms. Hilton attempt, or did she make any effort to explain perjury beyond what you just described for the court? Do you remember her doing that?
Doing this off the record or just in general?
In general?
Yes, she did.
Was the conversation that you are relating to the court that happened off the record, did it refer to matters that you later discussed on the record as well, or not?
All of it in sense was stuff that per se was explained on the record. It was just clarifying what would constitute perjury versus inconsistent statements, or what she would need to teach them.
And showing you, for instance, just page 50 of the transcript, line 11. I'm sorry, line 19. If you'll just take a look at it, is that an instance that is similar broadly in nature to the type of the conversation that took place off the record that you were just describing for the court? And by that, I'm talking about where Ms. Hilton is saying that's different, referring to the word purge. And Mr. Copeland says that can get me back in jail. And Ms. Hilton says yes. And Ms. Hilton in line 24 of page 50 says, it's not what you're saying, what you're saying is not perjury. What you're saying is what we call a prior inconsistent statement, and so forth and so on. Is that the type of conversation that took place off the record?
Objection, lady.
Sustained.
It
Sustained. Ask a different question.
Yes, Your Honor. During the conversation off the record, did Ms. Hilton endeavor at any time to help Mr. Copeland understand the difference between perjury and purge?
If you remember.
I don't remember if that was substance of the off the record. I do know during the course of the meeting, she repeated that several times, trying to explain the difference between purge and perjury.
And off the record, the comments, any comments that were the comments that Ms. Hilton made regarding hypothetical instances where perjury could be occurring, did she clarify for Mr. Copeland in any way? Did she seek to clarify how she would be able to distinguish between perjury and something that wasn't perjury?
Objection, lady.
Overruled.
The off the record conversation was very brief and very short. And there wasn't a whole lot of explanations because that had already taken place.
Do you remember anything that Mr. Copeland said in response to what Ms. Hilton said about being able to, if he got up on the stand and admitted something that she could prove he was lying about?
Yeah, is this you asking during the off the record conversation?
Yes.
Okay.
He said he wasn't going to do
Guys, sorry, I do need to stop the show. We have another sponsor, and I do this very rarely. I know you're all into it, but honestly, I believe this is Thinking from Texas, Whitney, who is your stream sponsor today. She just sent me $200 on Venmo. She dropped a $50 super earlier. I'm doing this stream solo. So Whitney, you know, I don't have my co-pilot here today, but I am bringing you guys this great content. And when women sponsor streams on my side, it really means a lot to me. So if you guys could type Whitney in the chat, it would mean the absolute world. It makes this type of work worth it. Whitney, thank you so much. Here she is right here. I love you too. Thank you, Whitney. You always show me and Lead love, and you know, it's been a long day, but it's completely worth it. Me and Lead will be back on his side tomorrow. But when you guys come over here, I can't tell you what that means, not only from a loyalty perspective. I know so many people are streaming this trial. So many people are covering it. We try to bring you guys educated experience and have fun at the same time. You know, Lee's not practicing right now. He's retired. And luckily you guys have caught me at a good spot where all I'm doing is living and breathing law because I'm getting ready for the bar exam. And I have so many friends that are defense attorneys and we talk about this. So many attorneys are in this chat. It really is a special community. And Whitney, thank you. That really warms my heart. It really does on a day like this. So guys, I'm going to go ahead and update the banner, but please give Whitney her flowers. She's an amazing sister, completely generous. And you don't meet people like this, you know? So I'm super grateful for you, Whitney. And thank you so much. She says, best of luck on the bar. Yeah, we're going to keep it going. We're going to keep it going, but let's get back to the trial, guys. And while Whitney was sending me that Venmo, I'm pulling up the transcript so I can follow along. I'm going to make some notes. And when we have some breaks, we can actually pull up the transcript together and talk about some of these things together. So Whitney, thank you so much again. Please, guys, spam Whitney in the chat. She is amazing.
And what is it that he said he wasn't going to do?
Get on the stand and lie for something he didn't do.
Do you have memory of him asking or saying something about not going to say that he killed Donovan Thomas?
That's a magic statement.
He didn't use that word.
Oh!
He said he wasn't going to take credit or say he did something he didn't do.
Do you recall that those words you just spoke were in response to a question about the murder of Donovan?
It wasn't a question specifically about Donovan Thomas. It was a question about him getting on the stand. It was a statement about him getting on the stand and taking credit for something he didn't do.
And broadly, do you recall Ms. Hilton making comments about Donovan Thomas that Mr. Copeland then made any comments about?
Other than if he got on the stand and took credit for something or said he did something that he didn't do and he didn't do. That was the only statement she made. And then he said he wasn't going to get on the stand to do that.
Now, do you have any memory of Mr. Copeland, either on the record or off the record, saying anything about a gray infinity that the state, about having information about the infinity that the state doesn't know?
He never said anything about an infinity to me or Miss Simone, Miss Hilton.
Did you ever endeavor to find out what he may have told Ms. Bumpus privately? I don't want you to reveal if you heard it. I just want you to know if you ever endeavored to find out what he may have said to her privately.
No.
And would it,
Go ahead.
would it have stood out in your mind if Copeland had made any kind of inculpatory remarks about the murder of Donovan Thomas?
Almost definitely. If he had made a remark about the murder of Donovan Thomas, then we would initiate investigation. And I would assign one of those lieutenants to assist me with looking into that.
Do you have any memory, any exculpatory remarks Mr. Copeland made about any defendant currently on trial or not on trial regarding the Donovan Thomas murder?
No.
I'm
Go ahead.
ceding the floor.
That's
Okay.
fine.
All right. Does your memory of what took place during any part of the conversation that were off the record, does your memory align with what you heard Ms. Bumpus testify about regarding off the record conversations?
The restroom break, just the restroom break.
And what about the content of the off the record conversations? Does your memory align with what her memory is as she testified about?
Not for the majority of it, no.
Would you tell the court any discrepancies between what you recall and what you heard that she recalls?
The off the record, like I said before, basically Ms. Hilton having the conversation about Mr. Copeland getting on the stand, taking credit or claiming something that he didn't do and that we know he didn't do. That was in just the gist of the off the record conversation before the judge came back in.
And what, if anything, did you hear Ms. Bumpus talk about that you have no memory of whatsoever, or that you can testify in your recollection did not happen?
Oh, they're trying to say she was lying.
The incident about the infinity, him claiming that I can claim all of this. The part about you coming back the second time, that's what stands out to me right now.
And was my absence from the interactions between Ms. Hilton and Mr. Scratch that. Your Honor, that's all the questions.
All right, thank you. Anybody from the defense side have questions for Investigator Long? Miss Love, do you need a cough drop? Because I actually have some if you need one.
Oh, she said, do you need a cough drop?
Okay.
Here comes Schardt. Shout out to Max.
Please court.
Okay.
Investigator Long, good afternoon.
Good afternoon.
I want to talk to you specifically about
Damn, I hope
the
she's okay.
off the record portion of the meeting on June 10th, 2024, okay?
Okay.
All right, and if I have it mixed up, was off the record versus on the record, just correct me. I'm trying to understand myself, okay?
Yes, sir.
All right. First of all, the off the record portion of this ex parte meeting, you said that Ms. Weaver, the court reporter, did come in to the judge's chambers, the judge's back room and chambers during
Thanks,
that
Jerry.
discussion, correct?
Everybody was coming in initially.
Okay, and that was before what we're deeming the off the record
That's
conversation, correct? And Ms. Hilton specifically requested Ms. Weaver not to take those communications down, correct?
I wouldn't say she directed Ms. Hilton, Ms. Weaver, but she did say she wanted to talk to Bumpus before we went back on the record.
She made the request, Ms.
Yes.
Hilton. Okay, and that was to remain off the record was requested by Ms. Hilton and Ms. Hilton alone.
Yes.
Can I get a little clarification there? So this is after the restroom break, right? Or whatever kind of break it was?
Yes, Judge.
Okay, and when Ms. Hilton said, I want to speak off the record to Ms. Bumpus for a minute, was Judge Glanville already in that room by then or not?
He had stepped in and then ended up stepping back out.
Okay, and so, all right,
Yeah.
thank you.
And you indicated that during this off the record portion, Ms. Hilton stated to Mr. Copeland that she would not pursue perjury charges unless it was a blatant lie. That was said during the off the record portion, correct?
No, that's not what I testified to.
Okay, when was that stated?
I don't ever recall her saying that she wouldn't seek charges unless it was a blatant lie.
Okay.
I think she was trying to explain the difference between the inconsistent statement and then a outright lie, if I can use that terminology.
Well, what did she say?
What do you mean you say?
Well, you said that when I said she would not pursue perjury unless it was a blatant lie, you said that was not what she said. So what did she say regarding that?
And off the record?
Yes.
Yes. Her statement or comment to Mr. Copeland was that if you did get on the stand and you took claim or took credit, just me paraphrasing, for something that you did, then knowing that you didn't, knowing we know you didn't do it, then she would seek perjury charges for that.
Okay. And you indicated, my understanding of your testimony is you indicated that at some point, Ms. Hilton specifically referred to getting on the stand and claiming responsibility for the Donovan Thomas situation. Is that correct?
Yeah, if he took credit for something he didn't do, yes.
But specifically, it was stated the Donovan Thomas situation, correct?
Yes,
Okay, and that was out of Ms. Hilton's mouth.
yes.
Okay, so Ms. Hilton specifically during the off the record portion referenced Mr. Copeland taking credit or taking responsibility for the killing of Donovan Thomas.
Yeah, it didn't come exactly like that, but yes, it just yes.
And Ms. Hilton specifically said that if Mr. Copeland did that, she would seek perjury charges against Mr. Copeland, correct?
If he got up and he took credit for something he knew and he didn't do, yes.
Well, you keep going back to, you know, you didn't do, but in the fact is in that off the record portion of the conversation, it wasn't just generally something we know you didn't do. She specifically said
It was both.
killing. Okay, so it was specifically something we know you didn't do. And then she also said specifically
Right.
for claim responsibility killing of Donovan Thomas. Okay, so to your recollection, if you recall, prior to Ms. Hilton, did Ms. Hilton just bring Donovan Thomas that case into the discussion, or did Mr. Copeland say something that Ms. Hilton was responding to when she warned him not to take credit for the Donovan Thomas killing?
Ask the question one more time.
What did Mr. Copeland say before then that prompted Ms. Hilton to start talking about Donovan Thomas's murder?
Mr. Copeland didn't say anything. I can only, I believe Ms. Hilton was attempting to just explain because he had received use immunity, not to go in and try to claim something that he didn't do because he received use immunity.
So your testimony is Mr. Copeland didn't bring up Donovan Thomas, but Ms. Hilton brought up Donovan Thomas murder.
Right.
Wow, he said right.
Did Ms. Bumpus bring up the Donovan Thomas murder prior to that?
Not that I recall, no.
And how was it determined when Ms. Weaver was going to start making a record of this meeting again?
I don't know how it was determined.
Did someone call her in? Did someone ask her to start recording now or taking minutes now?
Yeah, I believe if you're asking what made her prompted to, yeah,
Yes.
we said, I don't recall if it was Ms. Hilton, but Ms. Hilton may have said we're finished talking, and we called everybody back in.
And instructed the meeting to go back on the record? Instructed that the meeting should go back
I
on
don't
the
know if we
record?
instructed, but we were clear to go back on the record.
I have no further questions. Thank you.
Thank you.
Go Max. Shout out
Anybody
to
else?
Evelyn and Scraping. Also, can y'all please get, I mean,
How you doing?
are we
Mr.
gonna
Speaker?
get my likes up? Are we gonna do it?
I'm doing fine. Blessing, how's the favor?
That's a
Can I
steal.
ask you a couple of questions?
Yes.
What was your understanding, if you had one, of why you were having this ex parte meeting?
Sustained.
At what point were you initially told that you're going to this ex parte meeting? I want to know which part he was there for. The beginning part, he said he came with Miss Hilton. I want to clarify.
Ask your question again.
At what point did you become aware that you're going to this ex parte meeting?
I'll allow that.
Yeah, that's a clean question.
I believe that morning.
And when you say that morning, was it before the meeting began? Do you know when the meeting began?
It was before.
Okay.
It was before the meeting.
And who alerted you that?
Ms. Hilton, I believe. Yeah, because of course we had to escort him over to the judge chambers.
And did you escort, when you say them, who did you escort to this? Say one more time.
Ms. Hilton.
And was Adrian Love already there in the meeting, or did she come with you or go after you?
She was already there.
All right. Now, how often, besides this day, have you had these type of meetings with Judge Glanville?
With me, just this one.
How about with other people that you know about?
With Judge Glanville, no. Never happened with Judge Glanville.
Well, in this case.
Just this one.
Okay. All right. Thank you. Thank you, Your Honor.
I love the way Brian does it.
Anybody else? from
It's
the
silent
defense?
murder. Okay. Like he gets what he needs, gets out.
Go ahead.
Did anybody tell you that that was not to be told to other people who are not invited to
Ooh.
that meeting?
Ooh.
What's the relevance of that?
The state of Georgia, I objected to it, made a statement that I somehow knew about this beforehand, which is not true. So I want to ask if anybody directed anybody to tell somebody from the defense, not tell anybody from the defense.
I'll allow it.
Your Honor, I did not represent to the court.
That's fine. It's all right. I'm going to allow the question.
It's coming in. Sorry.
If I understand you correctly, you don't want to tell me not to say anything.
Mhm.
One more time, you spoke very fast.
I'm sorry. Was your question, did anyone tell me not to say anything about this meeting?
Yeah.
No.
Did you tell anybody about the meeting? Did you personally tell anybody, me, any of the other defense lawyers, any of the people accused of this meeting?
No.
Thank you, Your Honor.
All right.
Mr. Matthews. While Mr. Matthews is making his way over, what is your recollection as to sort of when during the meeting, like within the first 10 minutes, within the last 10 minutes, right in the middle, if you recall that the bathroom break and then short off the record conversation occurred that you testified to?
This was near the end.
Near the end?
Near the
Okay.
end.
All right.
Good afternoon. How are you today?
Mr. Mathis, how you doing?
Doing well, thank you. Just a couple of questions. Did you have any recording devices in the meeting yourself?
No.
Did you make any written notes of any of the meeting yourself?
No.
Okay. And just for the record for today, you were actually in the courtroom during the time that Kayla Bumpus was testifying before this honorable court, correct?
That's correct.
Okay. Did you know this morning before court that you might be testifying about this matter today?
I did not know.
Okay.
I could ponder, but I did not know.
Okay. All right. That's all I have. Thank you.
All right. Anybody else? Any redirect?
Okay. Rule now.
When you spoke about the comment that Ms. Hilton made about claiming something that he didn't do, or the Donovan Thomas murder, did she qualify her comments in any way?
What do you mean by qualifying?
Did I hear, did she tack on anything about if she could or couldn't prove it? Or did she just say, if you do this, I will charge you with perjury?
She consistently, if she's mentioned charge, she would say that she would have to corroborate anything before we charge. But she did mention the fact of I can only speculate, I would use the word, the concern about him trying to take claim for something after receiving free use of immunity.
And were those comments that she made that you're talking about also accompanied by any kind of explanation, like if I can prove it or?
Yeah, because she mentioned the fact of if we knew, and we know you didn't do it.
Thank you.
Mhm.
Thank you.
Sorry,
Anything
guys. I
else
mean,
from the defense?
they're there. They're just not good fitting trousers.
All right, is the transcript before the witness at this point, where it went to?
Yes, Your Honor.
Okay, can you flip to page 41 and take a look at, well, the end of 40, starting at line 20, and then review that through the rest of line, or the rest of page 41?
Guys, on the next break, I'll bring it up. We'll look at it together. But I have the transcript. I'm following along with them.
Let me know when you're done.
Okay.
This is the immunity part for Woody, is what he's reading over. We're trying to get to the crux of it. What was said and what wasn't said. I'm going to read it to y'all in a little bit, but I have it pulled up here. She said 40 and 41. I think he page turned twice. Are y'all calling him YSL Trump? Is that what's happening?
I'm done, Your Honor.
All right, is it a fair characterization that during that portion of the meeting, Ms. Hilton, Ms. Bumpus, and Mr. Copeland are talking about what might or might not get him charged with perjury or false statements?
Yes.
And does Mr. Copeland raise the issue of murder and whether it has a statute of limitations?
He did.
Okay, and does Ms. Hilton at some point after that talk about if she knows that he's lying about something and there's no other evidence, what that might or might not result in?
If she's asking you, the answer is yes.
Yes.
Do you recall whether the off-the-record post-bathroom break conversation occurred before or after this on-the-record conversation?
Give me just a second. Let me look a little past just to make sure.
Sure.
Was it before or after the bathroom break?
But after.
After. Okay.
If you take a look at the entire rest of the transcript, do you think you might be able to figure out about when that break and off-the-record conversation happened?
I will take a look.
And I mean, you may or might not be able to, but if you can, let me know. If you can't, let me know that as well.
Yeah, guys, you guys are complimenting Judge Whitaker. She really is good. You saw a lot of that in her performance today. Great point, Kim.
Your Honor, I believe page 52.
You see her look up like, whose phone is that?
Can you find out whether that's somebody who has a Rule 22? And if it is not, they cannot come back in with that phone.
Mm.
Thank you. Go ahead, I'm sorry.
No problem. Your Honor, I believe 52, around 13, 14,
Okay.
when we come back in. Let's see.
Okay, I'm gonna pull that up too. Follow along with him, guys.
Yeah, I think it's somewhere around in there.
Okay. And a break is actually indicated at lines 9 through 13 or so. Is that right? Okay.
Right.
And then at line 14, the court remarks, Mr. Clopen, have you had an opportunity to talk with Ms. Bumpus, your lawyer, and Ms. Hilton, the state's counsel? Have you got any questions?
Yeah, because
So it's right before that the off-the-record
Yes.
conversation occurred? Okay, thank you. All right. Any other questions by any counsel? Defense counsel? All right. Anybody else? Silence equals none. Okay. Ms. Love, anything?
Yes, Your Honor, thank you. Chief Deputy Long, on page 40, lines 20 through 25, when the court refers to comments made to Mr. Copeland earlier by Ms. Love, did you ever hear those types of comments made by Ms. Hilton?
Ms. Hilton, yeah.
Was any time you are aware of that Chief Deputy Love, myself, would have been in a position to make those comments to Mr. Copeland that morning?
No, not with Copeland in the room. You weren't around at all.
Okay. Thank you, Judge.
Great
Okay.
observation, Brandy.
All right. Investigator, thank you. You may step down. Any other evidence, Ms. Love?
Not about, no, Your Honor, not
Okay.
at this time.
All right. Any rebuttal evidence from anybody on the defense side of the room? All right. Anything y'all want to suggest that this actually means?
What does it mean for the trial, guys? We have an off the record post bathroom break, not in the transcript. Let's talk. Max, I believe, is up first. Here's Max.
So, Your Honor, there's a case that I believe that Mr. Steele has shared with you. I'm trying to get this site right now. Ford Motor Company versus Young, 322 Georgia Appeals, 348. And that case when we've been discussing this in the past, there's been suggestions that if there was judicial misconduct or what we believe is judicial misconduct from this side of the room, or if there was prosecutorial misconduct or what we perceive to be prosecutorial misconduct from this side of the room, that the remedy was with the bar. And that case,
And quick interruption, guys. Your stream sponsor, a woman, Whitney, is asking a question. If you guys think there's Brady material that was not turned over to the defense, put a 1 in the chat. Put a 2 if you think otherwise. Back to Max.
Ford case indicates to me that Your Honor and the trial court can play an active role in fashioning remedies in the case of judicial misconduct and or prosecutorial misconduct.
I don't know about judicial misconduct. That's not what that case stands for.
Prosecutorial misconduct,
Okay.
or lawyer misconduct, I should say.
Violations of the state bar rules.
Yes, and can I go get one thing for myself?
Sure.
He's grabbing something at his seat. I see all 1s here. I do see a few 2s. Little gaming channels like, hello, 1. 1 to the a millionth power.
So I filed a motion on Friday.
Yes, I worked diligently over the weekend on writing an order with regard to that motion. Haven't gotten to the Brady portion of it yet.
She
So-
said, I
and
remember.
I appreciate that, Your Honor. I appreciate the attention that you've given it. That motion in the beginning lays out things that I've observed, that I've felt have been highly irregular about this case. The point of my inclusion of that in my motion was not to draw extra attention to it or for anyone to feel sorry for me or anything else, because it's really about Mr. Stillwell. But the purpose of it was to try to inform the court, at least from my perspective, and I think the perspective of some of my colleagues, that things have been irregular in this case. And that there are real life consequences and consequences to the trial when we perceive what we believe is the lack of
that
an
might.
impartial trial judge and also of prosecutorial misconduct. In this case, from my perspective, we've had with the ex parte communications in themselves, I don't believe that there was a valid reason to initiate the meetings. I believe that the state and members of the state's prosecution team in particular took something very small and jumped to unbelievable conclusions as a way to get their foot in the door of the judges' chambers to have a discussion. And there were at least 2 discussions that took place. I'm assuming that there was a 3rd discussion, which may have strictly involved the grant of immunity.
All right,
But,
well,
right.
I think we cleared that up on Friday because we specifically asked, was there any hearing or any kind of ex parte, anything with regard to getting the order, or was it just the motion being filed? So,
Right.
I mean, I don't have any reason to believe there's yet another one, but.
Right. And you know, there's a potential under the King case that one, if it was just for the purposes of granting immunity, may have been a proper parte. But these were not. The substance of these meetings exceeded what is appropriate. They violated Uniform Superior Court Rule 4.1, says that judges shall neither initiate nor consider ex parte communications by interested parties or their attorneys concerning a pending or impending proceeding. Georgia Code of Judicial Conduct Rule 2.9 prohibits ex parte meetings except for a narrow exception, scheduling administrative purposes or emergencies that do not deal with substantive matters or issues on the merits. Provided that, so we don't believe that it falls under an exception to begin with. Provided that the judge reasonably believes that no party will gain a procedural, substantive, or tactical advantage as a result of the ex parte communication. In my view, the transcript reveals open discussions about you're going to testify, you can say you don't recall. They're basically walking through the procedures for laying the foundation for prior inconsistent statements. To say that that doesn't put that meeting with just the judge and the witness who has been sworn in doesn't put the state at a tactical advantage over the defense who's excluded, I believe that to be the case. Secondly, even if it falls under the exception, the judge must make provision to promptly notify and give the parties the substance of the ex parte communication and an opportunity to respond. We were not promptly notified. We found out through, I keep saying, doggedness and happenstance. I believe that's what it was.
Shout out to Papa
We
V.
learned about it. And then when we asked for an opportunity to respond, we were promptly greeted with an invitation to go to the jail for 20 days. So that was violated. The Georgia Rule Professional Responsibility Rule 4.2 regarding communications with a person represented by counsel. The state, it's the worst kept secret in the courtroom that John Melnick represents Kenneth Copeland. Worst kept secret.
Seriously,
Everyone
agreed.
knew that.
Mm-hmm.
I knew that, and that's why I called Mr. Melnick.
Okay.
The state is somehow claiming that in this case where the world is watching, it's a huge case, that they did not know that Mr. Melnick was representing Kenneth Copeland, and they went behind Mr. Melnick's back and initiated conversations with Mr. Copeland. Let's be frank, all these gentlemen are facing RICO charges with overt acts going back to 2013. So this is not a case where Mr. Copeland could not possibly be prosecuted. He could easily be indicted. He could easily be indicted and put with the rest of the gentlemen who were severed off of this case and be in Rice Street right now. He was in legal jeopardy when the state was seeking to speak to him outside the presence of his attorney. From our perspective, that was a knowing violation of Georgia Rule of Professional Responsibility 4.2. Additionally, Your Honor, there's Bar Rule 3.3, candor towards a tribunal. Now, I can't flesh this out without Ms. Love taking the stand. I would love to ask her about it, but in the motion to grant Mr. Copeland immunity, in paragraph 12, I believe it is, they specifically stated that a member of the defense team had contact with Mr. Copeland, and that prompted him to begin to assert that he was going to exercise his Fifth Amendment right.
All right. I would prefer that since there continue to be allegations back and forth amongst the lawyers, that we specifically get what is actually stated in there instead of, and I know you're not trying to misrepresent anything, you're trying to give it your best recollection, but let's get the actual motion and read the actual words.
That's right.
Okay.
I want to see it too. And guys, I have it.
I've got it somewhere.
Okay.
So, look
got
at that
it right here,
too.
Your Honor, from Ms. Persifield's email to us.
I've got it. If you, I mean, if you've got it at hand, go ahead. But if you don't, I've got it now.
Okay. Trying to find out exactly, try to figure out where it was. Okay, paragraph
Go
11,
ahead.
I'm sorry.
Paragraph 11. Mhm.
Yes. And it says Kenneth Copeland has been subpoenaed to testify in the above style case. Copeland is the next witness scheduled to testify in this case on June 7th, 2024, beginning at 9:00 a.m. On June 4th, 2024, and June 5th, 2024, investigators with the Office of the Fulton County District Attorney coordinated and arranged with Kenneth Copeland to provide Copeland transportation to court on Friday, June 7th, 2024. However, on Thursday, June 6th, 2024, after an encounter with defense team members and members of the Fulton County District Attorney's Office, Copeland stated to an investigator and to an attorney with the Office of the Fulton County District Attorney that Copeland may attempt to plead the fifth to avoid testifying against members of YSL. I can only speak for myself. I did not have any encounters with Mr. Copeland on June 6th, 2024. I don't believe that any of my colleagues did. I don't believe any members of the defense
So
team.
who did?
I don't believe that what's asserted in paragraph 11, to my knowledge, I don't believe it to be the truth. If it is not the truth, and again, I would love to inquire, but Ms. Love would be a witness at that point. Bar Rule 3.3, candor towards the tribunal would also be
Oh,
violated.
ethics.
The reason I focus on the violation of these rules is because of the Ford case and the position that we can do something about this besides run to the bar. And that makes sense because it's ultimately if, and I say it did happen, and I say the transcript establishes that it did happen. And you have the transcript, Your Honor. We have in the transcript the state and Judge Glanville both affirming each other that Mr. Copeland can essentially be incarcerated indefinitely until this trial is over, until the trial of the defendants is over. That, to me, is coercion. That's intimidation. We have other examples where Mr. Copeland is given what I would say incorrect legal advice about what his exposure is for these allegations and his potential criminal liability. That is coercion. That's trying to convince him to take the stand and plead so that the state can then impeach him with his prior inconsistent statements, presumably. Mr. Copeland, the act of him taking the stand as a result of those ex parte communications has prejudiced, has harmed all of the young men in court here today.
All of
So
them.
there has to be relief beyond bar issues for them. Your Honor, I'm not going to repeat everything in my motion. You have my motion. I know you've read my motion. But they have a right to a trial. They have due process rights. They have a right to a trial free of prosecutorial misconduct if that misconduct rises to the level of a due process violation. They have an absolute right to a fair trial and due process in front of a fair and impartial trial judge. They also have the right to be present at all critical stages of the proceedings, including, I'm saying, and I think it's fairly clear, that those ex parte communications talking about the witness under the Scudder case that I provided to the court before, that was a critical stage and they were unlawfully excluded. And of course, there's no way we could have acquiesced because we knew nothing about it ourselves. So those are all violations that have harmed these individuals. There has to be a remedy. I believe that the facts are there for you to consider disqualification of district attorneys in this case. And I think Mr. Steele is going to argue that further. But also, I believe that the
Wow.
facts are there under the Wilson case, as well as
So guys, Max has filed a motion this past Friday. I was just talking to Thugger Daily, and guess what? Your girl got the motion. I also have the ex parte hearing, so we can look at page 40 together. But what is Max asking for right now? And yes, guys, we are 10 minutes behind for good reason. We need TiVo time. We need TiVo time. Max is asking to have 88 Love, to have Simone Hilton taken off of this case. Why? Because they had information that should have gone to the defense team. And the judge said, she's been saying it many times. She started the day saying it, saying that she was working throughout the weekend tirelessly to respond to Max's motion. We have Max's motion. And what he's talking about right now, he's talking about the remedy portion of that motion. I have that. What does that remedy spot mean? What does it mean? A remedy is, Judge, we know that something is wrong. What are we going to do to correct that wrong? Because these gentlemen have been in jail for years. What are we going to do to correct this wrong? Can we correct the wrong? And I think really Judge Whitaker hasn't interrupted him this entire time. Let's go back in and continue.
the State v. Jackson, 306 Georgia 626, Anderson v. State 285 Georgia Appeals 166, and Wilson v. State 233 Georgia Appeals 327. Wilson v. State 233 Georgia Appeals 327.
All right, and those are the three cases that y'all gave me a
Correct.
couple of days ago.
About goading. And the reason I cite to those cases, because it's not often, well, it would be never probably, that a district attorney or prosecutor is going to say, yes, I did this intentionally, I did this to goad. These cases looked at the egregiousness of the violation, the experience of the prosecutors involved. Ms. Love is a chief deputy district attorney in the office, head of the union of the unit
All right,
that deals.
can I interrupt you for just a minute? So all of this is in your motion, and if and when we get to that point, that would be an appropriate argument, but let's
Okay, well, that
pause
you
it for
asked,
now. I have it.
you asked where we are right now, and that's from my perspective,
Okay.
that's where we are right now.
All right. And I don't mean you can't argue anymore. I just mean
No, I understand.
the information about their qualifications is in your motion.
Yes, John.
All right.
Thank you.
Okay, and if Mr. Steele's going to argue as to something else, that's fine. But I had said a little while earlier that with regard to Ms. Love, your proffer about what Mr. Abadi might or might not have to say about Mr. Melnick's representation was not yet relevant. I think it is now relevant, and the proffer has not been accepted. So if you want to present evidence as to that, that would now be appropriate. And I don't mean this very instant, because I'm going to hear from Mr. Steele, but we now know that is an issue. So you can go ahead and get him lined up. All right, go ahead, Mr. Steele.
Come on, Brian. He's coming up.
Your Honor, I would just like the court to consider the case that was announced to this honorable court by Attorney Schardt. I emailed it earlier today to your honorable court's coworker and all the parties. It's Ford Motor Company versus Young, and it was 322 Georgia Appeal, 348. It's in Division 3, 745 Southeast 2D299, 2013 case. And what our second highest court wrote was, and I've given a copy actually to this court. And
Oh, yeah, I got the copy. I appreciate it. Thank you.
it's on page 8 of 9 of the copy I've given. It's on the right-hand side, first full paragraph. And it specifically states that in the center, and we have previously held that trial courts may disqualify attorneys for violations of disciplinary rules. We held that the trial court erred in ruling that because sanctions for violations of disciplinary rules appear to be the exclusive province of the Supreme Court of Georgia, not of the trial court, it lacked authority to determine whether plaintiff's counsel violated 4.2, Rule 4.2 of the Georgia Rules of Professional Conduct, and therefore should be disqualified. We noted that the determination of whether an attorney should be disqualified from representing a client in a judicial proceeding rests in the sound discretion of the trial judge. So I'd just like you to reconsider your order, not disqualifying Ms. Hilton and Ms. Love. And you've inherited a case that has a lot of
Problems.
has a lot of history and a lot of it bad. And I put into my motion, I could go over it with the court, and I also attached the YouTube links. It's on July 10th, 2024. I also filed a case, the link where I filed on a thumb drive to preserve it. So that's the clerk's office, and a copy was sent to the prosecution as well. But it started before, but an opening statement. I don't know if you've read it. So
I read your motion and I looked at the portions that you were talking about.
hurtful. It's hurtful. And then as of last week, a new court comes on. It's almost like a breath of fresh air. It's all new. And again, I'm hit with emotion by Miss Love. That was the fourth time the same thing's argued. Talking about a duty that is intentionally and knowingly not followed through by me, and I owe it to her. And I saw your email saying, whoever wrote that, you come into court. I understood it.
I don't think Miss Love did herself any favors with that.
Well, the favors have to end. I've never done this before in my history of living in a courtroom. But it's just not appropriate. I can't accept a proffer from a lawyer. I've never said that before. I've never uttered any of those words. So I'll leave it with you. My point is, it doesn't end. There have been no sanctions. It's been ratified almost. And it's from everything. It's just, I put in paragraph 2, just choice examples from my memory. But it is constant. There are great people everywhere in the courts, and they shouldn't be treated like this. So I'm asking you to disqualify because it's just not, at some point, the message needs to be sent that this is not the state of Georgia and this is not our bar.
All right, thank you. As I understood the gravamen of your motion that you filed since I've been the presiding judge to disqualify Ms. Love and Ms. Hilton, it was because you needed them as a witness, and that was the basis of my ruling. And in Mr. Schardt's motion that is under consideration right now is a request, again, to disqualify them. And I know that I previously said, y'all, that's a matter for the bar. And when I was talking about that, I essentially meant the and I don't want to call it bickering back and forth because I'm not sure it's been back and forth to any large extent, but that kind of thing, whatever it is that had been talked about before, that's what I was talking about. I will tell you that this court takes Brady violations very seriously.
Yes.
And I mean, everybody ought to, prosecutors ought to.
Mhm.
And I am considering that right now. So rest assured that I am aware and have been aware that I have the authority if I choose to remove them.
Thank you.
So, all right.
Yo.
Do y'all want to be heard from the state on this? Or do you want to go ahead and present some testimony to counter the Melnick, that you knowingly contacted Mr. Copeland, knowing he was represented by Mr. Melnick?
Absolutely, Your Honor.
All right.
What we did was ask that our witnesses be summoned, if you will.
Okay.
If the court
All
would
right.
just give us.
Sure. Why don't we take a convenience break, and can you let a deputy know when you're ready with somebody, and we'll come back out.
Yes,
Thank you.
thank you.
Appreciate it.
Oh my God, guys. Okay, so they're taking a convenient break. You guys know I like to have a 10-minute buffer, so I will bring it back up to speed. It looks like they're still at break right now. We're about a minute. We're actually on time right now. So as soon as they come back, we will know. Well, this day has been crazy. Shout out to you guys if you've been rocking with me since 9 a.m. East Coast time all the way till now. We have seen so much, but what did Judge Whitaker just say? She said that John Melnick testified this morning and that the prosecution had knowledge that Lil Woody was represented. And what did they do? They did not care. They proceeded to talk to him anyway. Judge Whitaker just said she is considering Max Schardt's motion to disqualify. And while we're waiting, I might as well just show that to you guys, right? Let's go in over here. We're going to share this tab. This is filed from Max and Shannon Stillwell, 4:06 p.m. Friday afternoon, this past Friday. So this is after I stopped streaming. And there's a few things. This was submitted to Judge Whitaker. It's a renewed motion for a fair and constitutional trial and appropriate remedies for constitutional violations. What is this about? Brady material. We talked about that. And a lot of you guys have been asking about the word proffer and what that means. The word proffer in the law really means an offer or an endeavor to proceed in an action. That comes from Black's Law Dictionary. Every attorney knows that's where we get our definitions from. In the context of a trial or a hearing, a proffer is an offer of proof where an attorney informs the court about evidence that it has been shown instead of presenting it. That is a big portion of what we've seen for the day, okay? So when Melnick comes in, the judge said, I wanted to give him an opportunity to clear his name because it has been understood that, the way that the prosecution is writing these documents is that the defense team, they're like the big bad wolves. They've been blowing the house down, like, the big bad wolves. And really what they're trying to do is take care of their clients. Even Melnick was trying to do that with Woody. He was trying to do that. But we saw, and it's been exposed this morning. So I know we got distracted with Kayla's testimony, but this morning, the big thing that we saw in this morning's session was Melnick testifying, standing on his square. He did a superb job. And he was just like, Miss Love, I don't care what you say. Miss Love, you knew he was represented. You can ask me all these irrelevant questions. Miss Love, Judge Whitaker stood on the sand and said that in an unrelated matter, she knew that Melnick was Woody's attorney. So she's also mentioned that this document that we're about to look at, that Max filed on Friday, hasn't been ruled upon yet. She is working on her order. So it is likely that if we don't get it from her tonight, that we'll get it tomorrow. So that means when Lead and I come back together, we'll be able to break this down. Now, what is Max asking for? He's giving us the background facts. I'm not going to go into that too much because I think at this point, you guys know what those background facts are. The case got removed from Judge Glanville and got put on to Judge Whitaker's radar. Next, Max talks about Stillwell's rights. that's fine. I'm going to skip through that. He also talks about examples of error, impropriety, prosecutorial misconduct, and judicial partiality. So he has 4 main arguments here. They talk about discovery violations, lost and missing police reports, and Brady violations. All of those things. Discovery, when you're a defense attorney, you have to work with the prosecution side to get evidence in, right? You can't hide the ball. You have to show what comes in during discovery. You have to talk to the other side to show them what you plan on introducing as evidence. Lost and missing police reports. The question becomes how? Lost and missing police reports. How? Lost and missing police reports. Where? It's a police report. How do you lose a police report? I don't understand. But the biggest part is Brady violation. So think about if you're a new judge, guys. You're a new judge. And the defense attorneys have been coming to you. They're like, hey, this has been the dumpster fire. It's been on fire for a long time. Do you want to go get the extinguisher? Because I think we should put the fire out. It's been burning. Nobody cares. Everybody just walks by. The bystander effect. Like people see it burn and they're just like, hey, something's burning in Fulton County. We're going to do anything about that? No, it's just on fire. Max is like, Judge, what are we doing? What are we doing? Sorry, those people are like, dang, AV, my ears. Sorry. My mic is on the lowest setting possible. I apologize, but I get passionate about this stuff. So let me whisper for the people in the back that don't want me to speak loudly. So we're talking about this, right? And he is talking about Brady violations. That's the most important part of this because this is a constitutional right. A Brady violation really comes at a defendant's rights across, what they would get in any state, right? Max goes on to say this case has been plagued by improper legal rulings, included but not limiting to an overly liberal and unconstitutional application of the statute. Defense counsel has routinely been cut off by the prior trial judge when arguing these matters and rulings that have been made with little or no analysis. This case has also been exceptional in the treatment, actually mistreatment of defendants and defense counsels. Examples include, but not limited to, A, an incident which occurred on or about October 2nd when Judge Glanville initiated a contempt hearing against undersigned counsel Max Schardt, attorney for Mr. Stilwell. On this date, Judge Glanville sent deputies to find Max during the court's lunch break and summon undersigned counsel. Sorry, guys, we're back. We're back. We'll get back to that, but we're back.
All right.
As they do that, I had no idea that they went and found Max and tried to lock Max up. Wait, can we go back? Let's just finish that sentence. Let's just go back to the sentence. Just the sentence, because I want to know what happened to Max. So there was a break, and they went to go get Max, right? A courtroom deputy informed undersigned counsel that Judge Glanville was expecting an apology from counsel for calling him or calling out some bullshit in open court. While in chambers, undersigned counsel was advised that he should not deny the accusations as well as it was captured on video. When undersigned counsel refused to apologize for something he did not do, Judge Glanville instructed counsel to leave his chambers. Later that day, Judge Glanville initiated a contempt hearing against Max Schardt. Judge Glanville berated Max and threatened incarceration. Judge Glanville accused undersigned counsel of violating bar rules and putting his law license in jeopardy for lying to the tribunal and not confessing his sins. In the end, attorney David Botts, who was sealed within feet of undersigned counsel at the time, spoke up and stated that undersigned counsel never made such statement. Of course, the video captured the event in quotes was never produced and no apology was made. So it looks like Max is cooking over there, but let's get back to the trial. I just thought that was really interesting, but the judge has been reviewing that document that I just read to you guys, and we just read a piece. She's been reviewing it all weekend. Let's keep going.
I remember one time when I was called as a witness in a case for some very ancillary matter, and We're so used to being the ones examining. We're not used to being the witness and the direct finish. And I got up to leave, just like all of the lay witnesses who have no clue. And then I felt like an idiot. But oh well, maybe Mr. Abate won't do that. We'll see.
All right, so we have another ADA being called as a witness. He's coming in.
You're coming up to the witness stand.
Like Mr. Melnick, I'm an officer of the court. He can swear himself in. but
Oh, this is
whatever.
Post-it Kid from the
All right,
Fanny
let's-
thing.
let's-
Like Mr. Melnick, I'm an officer of the court. He wasn't sworn in, but yes.
Thank you. Good afternoon, Chief Deputy Abadi. How are you?
Fine, thanks.
Just for the record, would you state where you work and what your position is?
DA's office in Fulton County. I'm the chief deputy of the Major Crimes Division.
All right, and February the,
It's ABBATE. And I said chief deputy of the Major Crimes Division.
February of 2023, where were you working within the DA's office, if anywhere?
Same position.
All right. During that time, do you recall having a conversation with an attorney by the name of John Melnick regarding a person by the name of Kenneth Copeland?
Yeah, it was a conversation on a Zoom call where Judge Whitaker was on the call and heard all the contents of what I testified to. Yes.
All right. And would you tell the court what the purpose of that Zoom call and that conversation with Mr. Melnick was?
It was related to a bond order or bond conditions for a bond order for his, I think it's 22 SC 182. I can't.
Guys, this is a quick explanation for those that are coming in. We have a person from the prosecutor's office. We have another ADA from the DA's office of Fulton County on the stand. I had to quickly pivot because we were reading a document while they were on break. But ADA Love is, she is examining on direct someone, one of her coworkers. This is the guy. I don't know if you guys remember when Lead and I were covering the Fonnie Willis, Nathan Wade thing, and Steve Sadow had all these people on the stand, all of that. This is one of the attorneys that was representing Fonnie Willis, and we called him the Post-it Kid because Fonnie Willis kept giving him Post-its to say what she wanted him to say or to add points and things of the like. In my mind, this is Post-it Kid on the stand because he is rather young, but why is he being involved? Those emails that we read this morning, 4 emails that we went back and forth on this morning when Melnick was on the stand, Abate was involved in that. That is a gentleman that we see on the stand. He had a discussion with Melnick, and Love is brought him in as a witness. So we're going to see what he has to say, what information he can reveal about the Melnick piece, because the reason why I went to Shannon Stillwell's document, the reason why I went to Max's document, and the reason why is because the judge just mentioned, hey, guess what? We need to determine if there was a Brady violation here, and we're going to decide on that today. That is your explanation. Let's go back in and see what they have to say.
I think maybe 134. It was his possession of a firearm by a convicted felon and reckless driving, I think is what it was.
Okay. And did you have occasion to look at the bond order and see its contents, or the proposed bond order? Had the state proposed a bond order?
Yes.
And did the state's proposed bond order have any reference to or any conditions that are related to Mr. Copeland's witness, position as a witness, in this case, 22 SC 183572?
No, not to my recollection specifically, no.
Did the bond order or the proposed bond order reference co-defendants? Let me ask this. Are you familiar with the co-defendants on, or the defendants on indictment 22 SC 183572?
Some of them, yes. I've tried. I think Khalif Adams was somebody who I was the prosecutor who, when he was convicted of murder.
And the bond order, did it reference some of the defendants on this case?
I think it referenced all of the defendants on the case involving Jeffrey Williams.
Did the bond order, well, Your Honor, I'd ask the court to take judicial notice of the bond order, which is in this case
I'll take
already
judicial
filed.
notice of it, but I'm also just going to print it out right now and make it a part of this record. So it'll just be easier.
And I did misspeak and say, in this case, it is actually in Mr. Copeland's 22 SC case.
Yeah, 22 SC 182134.
Thank you. Would you please tell the court the content of the conversation or communication you had with Mr. Melnick regarding Mr. Copeland on that day?
Yes, it was. So it was me, myself, Abigail Potter, who at the time was the trial division lawyer assigned to Judge Whitaker's courtroom. Judge Whitaker and Mr. Melnick, and I believe Ms. Rosser, the case manager who set up the Zoom link, was on the Zoom. And it was just a discussion as it related to the bond conditions for his possession of a firearm by a convicted felon case that was before Judge Whitaker, and the conditions that would be included in it.
Was there any part of that conversation that referenced
She threw the damn mic.
Mr. Melnick representing Mr. Copeland as a witness in this case?
Yes, specifically. And the reference is that Mr. Melnick was all hot about the fact that I was on the call representing as a representative pretty much for you as a member of the team for this case, because he specifically said on more than one occasion that I'm not here about that case. I don't represent him on that case. The only case that I have before this judge that I represent Mr. Copeland on is the 22 SC case. He said it over and over again, and he kept making snide remarks as it related to you and the district attorney's office and eventually me, to which I said, I finally interrupted him. I said, we're done with your used car salesman, stuff. And that's when the judge was kind enough to intervene and say, all right, whatever, we're here just for the 22 SC case. We understand you don't represent him in the YSL case because there's nothing to represent him on, was the gist in my recollection.
And when you're talking about the 22 SC case, are you solely meaning the one Mr. Copeland faced charges on, criminal charges on?
Yes, the one that was before Judge Whitaker that we were there for to, negotiate and agree upon bond conditions for. That I think it's 22 SC 182, I think it's 134, and the charges were possession of a firearm by a convicted felon, and I think reckless driving. I think this all happened February 24th of 2023.
Do you know whether that Zoom call was transcribed or whether or not there was a court reporter on that Zoom call?
I'm not sure, but I don't remember seeing, I think it was Miss Evelyn, who was the court reporter back then. I don't recall.
Do you recall how many times Mr. Melnick stated with any degree of emphasis that he did not and was not representing Mr. Copeland in his capacity as a witness in 22 SC 183572?
2 or 3 times, and it was all in relation to the state's request that he be fitted with an ankle monitor. And that was particularly angersome, I guess is the correct word, as it relates to Mr. Melnick's reaction, because that's when he kept saying, this case has nothing to do with that case. I have nothing to do with that case. I don't see why he has to have an ankle monitor.
Are you familiar with what it is that the state was trying to secure with the ankle monitor?
His location at all times, I suppose.
And are you familiar with
Shout out to the lean.
Did you speak with Mr. Melnick at any other time regarding his representation of Mr. Copeland as a witness in this case?
No, I try to avoid him as much as possible.
Has he ever in life represented to you that he represents Kenneth Copeland as a witness in this case?
No, it was the exact opposite in front of the exact same judge that we're sitting before today.
A folder was just passed to the prosecution team. Now being passed to Love.
And showing what our market states is it's two, Your Honor, I don't know if the court had already-
Here you go. Here's the bond order.
Showing you State's Exhibit 2, which I'll mark, which is a copy of the filed bond order. Is that the bond order that you spoke with Mr. Melvin about on the date that you're speaking about now? Or is there?
So this would be the bond order that came from the conversation we had in February, I think February 23rd, excuse me, February 24th of 2023. This is this is stamped for March 3rd. So there would have, the whole reason for the Zoom was to negotiate and come to some sort of agreed upon set of bond conditions as it related to Mr. Copeland and being released on bond for the 22 SC 182134. That was right. So this would have been the product of that conversation.
Okay, thank you. All right, that's all that I have with this witness, Your Honor.
Okay.
All right. Any questions by any of the defense attorneys for this witness?
Hmm.
Nope, nope. Ms. Weinstein, Mr. Matthews, Mr. Harvey, who I can't really see over there in the corner. Is he even there? Is Mr. Harvey over there? Anybody for Mr. Harvey's client? Any questions? Okay, great. Thank you for your time. You may step down.
No questions from the defense at all.
All right, call your next witness.
State calls Attorney Peter Herzog.
Okay.
Oh, PETA. We talked about this guy earlier. He was a part of the email chain. Let's bring in PETA. I had to hit you guys with a little bit of a Boston accent. Some of you guys are asking why they didn't have questions for him. That is a good question. I really can't tell. It's very rare where the defense hasn't had questions for any of the witnesses so far. I think it's very clear why Adam Abate, which is his name, the gentleman we just saw, it's clear on why he was talking to Melnick, but it was a previous charge that Woody had. So I don't think those facts are in dispute, which is probably why they didn't have questions for him.
It doesn't matter to me. I mean, do you want him sworn or do you want him to testify in his place?
I'll have him sworn.
All right, yes, please swear him.
Next witness.
Tell the truth, the whole truth, nothing but the truth.
I do.
Peter, P-E-T-E-R, Herzog, H-E-R-T-Z-O-G. T-Z-O-G.
Good afternoon, Mr. Herzog.
Good afternoon.
Would you please, just for the record, state for the court where it is that you work and what position you hold there?
So I'm a senior assistant district attorney in the anti-corruption unit of the Fulton County District Attorney's Office.
Another
How long have you
employee.
worked in the anti-corruption unit?
Since I started in the office, about a year, I think I started March of 2023.
Did you say March? And I just need to speak up a little bit louder. March 2020?
Yeah, I think it was March. I've been here about a year and a half.
Have you ever worked in any unit besides the anti-corruption unit?
I did a short stint where I screened cases and then I cover a court part for a complex, but I've always remained in anti-corruption.
As an attorney with the anti-corruption unit, have you ever had an occasion to speak with Mr. John Melnick about a person by the name of Kenneth Cole?
Yes, I believe so.
At any time during those conversations, did you ever in any way seek any information regarding Mr. Melnick's representation of Kenneth Copeland as a witness in the case 22 SC 183572?
No.
Did you ever, in any of those conversations, have any occasion to talk with Mr. Melnick about his representation of Kenneth Copeland as a witness in any YSL related case?
No.
Did you ever, during your conversations with Mr. Melnick, reference either myself or Deputy District Attorney Simone Hilton?
No, not to my recollection. No.
Have you ever been asked by either of us or anyone prosecuting the YSL case to reach out to Mr. Melnick?
No, absolutely not.
Is this the longest you and I have ever even talked?
I believe so.
Yeah.
If I ran into you once in the hallway and said hello, other than that, I don't think we've had much contact.
Did the matter that you spoke with Mr. Melnick about have anything to do, in any tangential, direct, indirect, any way, have anything to do with 22 SC 183572 or the criminal indictment that preceded?
Absolutely not. No.
Was the case that you spoke with Mr. Melnick about a case that was in your unit?
Yes, ma'am.
Were you ever asked by anybody in the DA's office to have any communication with Mr. Melnick regarding his representation of Kenneth Copeland as a witness in this case?
No, ma'am.
Did Mr. Melnick ever just tell you, hey, I'm representing Kenneth Copeland as a witness in the YSL case?
No, not to my recollection.
Do you recall sending Mr. Melnick an email back in March of 2023?
March of 2023. I don't recall.
Your Honor, I'm not certain exactly where the evidence.
I'm sure it's somewhere with the court reporter.
It's one of the emails. They're going to put it in front of him to say, hey, did you write this?
I'm going to show you what has already been admitted as defendant Williams number 4, Your Honor.
All right. Email number 4 is how he came in.
And I'm going to show you ask you to take a look at the bottom portion of defendant Williams number 4. And ask you if you recognize or if you recognize that time frame as a time frame that you reached out to Mr. Melnick.
I did reach out to Mr. Melnick. It could have potentially been around that time frame. If you'd like, I can go into more detail.
Yes, please.
So we were investigating as part of anti-corruption. We were investigating.
Without getting into the details of any anti-corruption case
Okay.
at all.
There was an allegation made that involved Mr. Copeland. At the time, I was relatively new to the office. I'm not from here. I'm from New York. I spent years practicing up there. So I know nothing about what's going on down here in relation to this case. I reached out to Mr. Melnick to see, as per our usual in our unit, to speak with every witness. And I believe I asked him if Mr. Copeland wanted to talk about that specific matter. And I don't believe we ever followed up on it.
Was Mr. Copeland in jail at the time that you reached out to Mr. Melnick?
I believe so.
So was when you reached out to Mr. Melnick, where and why did you seek to go through Mr. Melnick to get to Mr. Copeland?
Because if I remember correctly, he represented Mr. Copeland in that other matter.
To your knowledge, had that other matter been resolved?
At the time, I'm not sure if it was resolved at that time. I don't believe so. I think that's why I went through Mr. Melnick, I believe.
Outside of the anti-corruption matter, did you speak with Mr. Melnick regarding anything else related to Mr. Holt?
No, ma'am.
That's all I have.
All right. Any defense examination of this witness?
Any defense lawyers want to talk to him?
You know, I did a thing, I wrote a check mark, and I'm gonna have to get that off.
Okay, probably have some white on it. That would work. Is that okay with everybody if on states 4, Miss Love White felt the check mark she inadvertently wrote on states 4, which is why I don't like to ever handle the evidence because I'm constantly taking notes and then I end up writing on the evidence.
And it's defendant, Williams exhibit.
Is that okay? All right. Thank you.
Okay.
Of course, permission, I'll do that after Mr.
Max is up.
Schardt.
Max wants to question this witness.
Go ahead, Mr. Schardt.
Good afternoon.
So from what I understand, March 2023, you are working for the DA's office in anti-corruption.
Correct.
Okay, and you are building up a case?
Yes. I'm investigating a case. I'm not building up a case. I'm investigating a case.
And is Mr. Copeland the target of this case?
No.
Okay, so he is a witness.
Yes, he would have been a witness.
And he's a fact witness, I assume?
Objection, Your Honor, to the relevance of what type of witnesses.
Sustained.
What kind of case is this?
Objection as to the.
Well, can we just leave that it's an anti-corruption type case?
I ask, was Mr. Copeland the alleged victim?
No.
So he's a witness.
Well, it's,
Your Honor.
Yes. Do we need a bench conference? Okay.
All right. So Miss Love is coming up to talk with the judge and Max. They might not like certain language and things of the like, because as you guys could see, we got stuck on that question a little bit. We couldn't move on from it. So we'll see what they come up with. I'm going to skip ahead so we can go live. Everybody's like, why are you so far behind? I do it for TiVo time for moments like this. For moments like this. Skipping ahead just to see if we can get us current. And it looks like another member from prosecution went up there. They're still talking. They are still
Mr. Schardt relaying.
All right, here we go.
The earphones work right now. So what I'm wondering is if y'all would be comfortable with Ms. Schardt relaying the substance of the bench conference, or if each of you wants to try to come up and gather around, or.
And Your Honor, since we cannot have, since we don't have the ability to let it be heard, I'd ask that the court ask whether each defendant waives their presence at the bench conference.
So do the attorneys want to come up, or? Okay, so I know the defendants normally are able to hear what's going on. I'm sorry, we're having technical difficulties. Apparently you need to put these things on their charger pretty frequently in order for them to work. So I'll know that for the next time. One of your attorneys is going to come up and listen to what the substance of the bench conference is, and then I'm directing them to return to the tables and let you all know what we talked about. I want to find out whether that's okay with each of you defendants. And also, I am happy if you're not satisfied with what the attorney has told you about it, to then you can let me know and I can say, well, here's my take on what happened. Okay. So, Mr. Kendrick, are you okay with Mr. Weinstein just coming up and then telling you what we talked about? All right. How about you, Mr. Huey? All right. Thank you. Mr. Williams? Okay. Who else do we have? Mr. Stillwell, are you okay with that? All right. And then Mr. Ryan, you okay with that? All right. Thank you. Appreciate it.
Okay, defense lawyers are approaching. The reason why is because they're having a sidebar
So y'all
discussion.
can't even get it.
It's being muted right now. The judge needs to have a discussion between the prosecution and the defense lawyers. Usually what they've been able to do, instead of having this army of attorneys approach the judge's bench, what they have been able to do is to give the defendants earphones. Now, of course, it's Fulton County, so they did do that earlier in this morning's proceedings. However, all of those headphones, all of those devices have died because they were not charged. Judge Whitaker has mentioned that just now. She's like, hey, I'm new, and in the future, we will have these devices charged every morning, but those have died. So what she is doing instead is letting them all know, like, hey, you know, you will have to come up for this sidebar, and your defense attorneys will come back to the table and let you know what's going on and what we're talking about. So yes, I mean, you guys are like, shake my head, like, what a mess. I mean, yeah, it's Fulton County. I mean, that's what's happening. So in the meantime, I will read a few supers, but we are all caught up. So as soon as they start talking again, we'll keep going. I did star some of y'all comments when y'all have excellent questions. G Baby at the beginning had a question about Brady. I think we covered that. Shout out to the Little Gaming Channel with 10. He says, why does Love pants pockets look like two eyes wide open? Her pants look like a big face. Well, I mean, guys, I think at this point have been a master in professional clothing. I don't wear them when I'm streaming, but your trousers should not have pockets that look like that. They're usually buttoned or they're stitched. They are not intended to be open. So that's what I have to say on that one. Shout out to Michelle with $1. Says, no comment, no question, but it looks like she's back with $5 with a question. She says, is it improper for the DA to offer immunity to Woody when he wanted to plead the fifth? No, they can offer it. They can offer it at any point in time. But what we learned this morning is that it was offered. They were going to have him testify without it. So we learned that this morning. That was another bombshell from Melnick's his testimony this morning, is he was trying to protect Lil Woody and his interests in his life. And DA Love allegedly said that Melnick did not have Woody's best interest at all. Okay, looks like they are returning. Max is back at the podium and DA Love is going back to her seat. So we should be getting sound in a moment or two. I don't see Judge Whitaker, so maybe we have time for another one. Shout out to Savvy Amira. I got your DM, sis. Thank you for becoming a member and congratulations on your recent win in life. We will be in touch soon. Shout out to Talking Trash and Truth. Gifted 5 memberships. Say thank you if you got it. I saw a few of you say thank you. That is amazing. It looks like she's getting ready to speak, but not quite yet. Shout out to I Got Gas with $10. Says, that's right, Brady versus Maryland, but I'm not a lawyer and I'm watching at the Holiday Inn. Okay. Thank you.
And do any of the defendants have any questions about it that they want to ask me? Okay.
All right.
And did you talk to your client about it?
I will.
Do you? Okay. All right, go ahead.
Attorney Herzog,
Spin your mic towards you.
the anti-corruption case that you were working on in March 2023, is that still an active investigation?
No, it is not an active investigation. It was and the investigation was wholly unrelated to YSL.
Okay, and is there a pending case involving that investigation that resulted from that investigation?
A pending criminal case?
Yes.
No.
Oh, that mic. It's that mic.
Now, at the time you sent this email, you wanted to speak with Mr. Copeland, correct? About the matters you were working on?
Yes.
Okay. And you have the ability as a district attorney, you said that your understanding is he was in jail, correct?
I believe so.
Okay, and you have the ability to go to the jail at 901 Rice Street, correct?
Yes, I have the ability to go to the jail.
Okay, and as a district attorney, you have the ability to bring an investigator with you and interview a witness there, correct?
I wouldn't represent someone I wouldn't speak with someone that was represented by counsel
Okay,
on any case or was recently represented by counsel.
okay, so the reason that you called Mr. Melnick is because you would not speak ethically, your code of ethics, you would not want to speak to someone who's represented, correct?
It's all of our code of ethics.
Correct. And you also would not want to speak to someone who was represented recently. Is that what you said?
I would reach out to the defense attorney prior to that, yes.
And that's what you did in this case. You reached out to Mr. Melnick, correct?
Regarding our investigation and the
I understand.
limited scope to our investigation.
Yeah, I understand. You were not involved in the YSL investigation, correct?
Correct.
Okay. But as part of your investigation, you reached out to Mr. Melnick in an effort to speak to his client, Mr. Copeland, correct?
Yes, I believe so.
I have no further questions. Thank you.
Does anybody else have questions for Mr. Herzog? All right. No?
Inquiry for the court.
Sure.
I don't understand enough about it, and I understand that the ruling is maybe I shouldn't know about it. With the court, Mr. Williams has no objection. And if you do, please correct me. Would the court be able to find out whether this has any Brady implications from Mr. Copeland, either under Giglio getting a deal or he did not get prosecuted because he was involved, but he was being used as a witness, and I don't have that information.
Sure, I don't either, but yeah, that's valid. Let's find that out.
Question for the
So you can ask that question. You don't have any objection to that question, do you, from the state? Okay.
Hello.
Mr. Still,
How are you?
good, how are you?
I'll let you know. Brady evidence, you feel comfortable talking about Brady evidence, what is required by Brady and its progeny?
Is this the question whether I feel comfortable?
Yeah.
Oh,
do you
Brian.
understand Brady
Oh,
and its
Brian.
progeny, what it includes?
Yes.
Okay. And I didn't mean that to be insulting at all. Just, some people have different definitions of something. Dealing with Mr. Copeland, only Mr. Copeland. Was there any type, no matter how non-promising, was there any type of agreement, promise, benefit to him, whether that's reduced charges, no charges, he's cooperating, he's a CI or whatever you want to call it, anything to do with that?
Absolutely not. I have no information regarding the YSL case or any investigation of the YSL case. I reached out solely related to a wholly unrelated matter.
Okay. And I'm broadening it besides what you call the YSL case. I'm saying, was Mr. Copeland given any benefit? Forget about this indictment before the Honorable Judge Whitaker. Was he given any benefit on any matter, including the matter you were investigating?
Not to my knowledge, no.
Okay. All right. Thank you, Your Honor.
Okay. All right. Anybody else?
I'll let you know.
Mr. Williams? Okay. Anybody? All right. Any redirect by the state? No, Your Honor. All right. Thank you. You may step down.
Thank you, Your Honor.
All right.
And did you have one other witness?
Yes.
Are they ready?
I couldn't allow Mr. Atkins to go outside and check.
Sure.
All right. This is the state so far has had how many witnesses? They've had a few of them. And 3 of them so far have been employees of the Fulton County DA's office. We had I think it was a deputy, not the deputy that ended up being the mole, but we had a deputy. We had 2 ADAs. Let's see if they are chatting again or if they're on mute. Looks like they might still be on mute. Not mute, but
Nothing.
taking a break.
Huh?
There was one matter, I guess, as it relates to Mr. Copeland, that I would ask that the court take additional notice of since they're all on here.
What's that?
The date that his criminal matter that we were just introducing testimony about was resolved. There should be within the 22 SC 183-134, I believe, case in Odyssey, a disposition for those criminal charges. I would ask the court just to take judicial notice of that date.
All right, so it appears that the plea was entered on June 28th, 2023, and the disposition was filed on June 29th, 2023, and I'll take judicial notice of that.
Let's see who they're going to call next. Hopefully it's not another employee from the DA's office. But all of that is for Melnick's emails. Can you guys imagine? Shout out to all the people that are buying Trial Watch merch. So she sent, DA Love just went to go check on their witness, and the person that went to check is back in the courtroom. So we are assuming that that person is coming in. If not, y'all know Judge Whitaker don't play with time.
All right, what do we know, Mr. Atkins?
So Ms. Potter is 30 minutes away. I'm not going to ask the court to wait on.
Okay,
I'm
okay,
sorry, he said 40 minutes, he corrected.
okay.
And so, rather than have the court wait on that,
We're going to do that tomorrow?
I can, yes, I can do that.
All right.
And Your Honor, the other, thing that I was looking at was I'm obtaining a certificate of service for Mr. Copeland that I believe was filed. I think he was served most recently in May of 2024. And if the court would indulge me one moment, I was just trying to determine who it was that served him, since the subject is state's actions regarding a witness, Mr. Copeland. And I would also argue to the court that there is not standing to complain of the interactions between state prosecutors and their witnesses in this case. And there's not standing to complain of what happened as it relates to Kenneth Copeland in the in-chambers hearing. But to the, on June 10th, in terms of King and its progeny, and what.
Man, I think I started a monster with these pants. Y'all are going in.
Reflecting.
All right. Well, their claim is a right to be present, and they have standing to make that claim. Whether I make a determination that they did have a right to be present or didn't is yet to be determined, but they can certainly make the claim. Was there, with regard to them, are there not being standing to complain about whether the state communicated with Mr. Copeland when, according to the defense, the state knew him to be represented? I understand the assertion in that regard to be that the prosecution has violated a bar rule, and that they've also violated other bar rules over the course of this case, and that I should take that into consideration in determining whether and what remedy to fashion. Do I have that about right? I'm getting nodding yeses. Okay. So yeah, they can assert that to the court.
Okay. And Your Honor, as I obtained for the court that those final two pieces of information.
Okay.
I asked for the court's brief indulgence while I get the certificate of service and the date that he was served.
Okay.
That because it was filed on.
All right. I'm not even sure which one you're talking about, but sure, if it's relevant, I will unseal it. Can you let me know which one it is?
It was a certificate of service and it was filed on. Okay, that's what we're getting today.
Okay. It's and that's in which case? This
22.
YSL case?
Yes.
Okay.
Oh my God, that got me crying about the pants.
So I actually, once you let me know what it is, I actually, because I'm the court and I can, kept a copy of what is in each of the sealed filings once I reviewed it, so that in case we needed to see something again, I didn't have to do another order unsealing and resealing. So those are in an envelope in my litigation manager's office. And when you let me know what it is I'm looking for, I'll just pull it out of there.
There is a certificate of service for Kenneth Copeland that should have been reflective of a subpoena that was served on him, I think in May of 2024.
Okay.
Without the exact date, I don't want to, I think maybe May 31st.
Okay.
That sounds about right. May
All right.
31st of 2024.
Sure. And maybe Ms. Persfield, you already are anticipating my need and sending an email to Ms. Rosser to see if she can pull that. Thank you. All right. And then with regard to Ms. Potter, is she gonna be available in the morning, or does she want to Zoom? I don't care if we take her testimony by Zoom if nobody else does. I don't even know if she's available, but that's an option as well.
Thank you, Judge. That would actually work. I'm gonna.
All right, would that be okay if, I don't know if everybody's familiar with Ms. Potter, but I don't know if is she still with the DA's office?
She is. She's
Okay.
outside.
She's a prosecutor with the DA's office who used to be in my courtroom and who was the prosecutor for the case that Mr. Meldick handled on the other side of. Would everybody be okay on the defense side with us taking her testimony by Zoom here in court? If anybody has an objection, please voice it orally now. Okay. All right, so that'll work. If you can line her up for that, and I think you already have the Zoom link, we can do that.
Thank you.
All right. And as Ms. Love's doing that, Mr. Atkins and whomever from this side of the courtroom was going to work on the maybe one or two issues with Mr. Copeland's jail calls over the weekend. Did y'all get an opportunity to do that and reach any kind of resolution?
Your Honor, I have not spoken with any defense counsel in relation to those jail calls.
Okay, wasn't that your task?
Your Honor, I will speak with Mr. Schardt.
Okay. I can't remember who said they were going to do that, but I don't know. Y'all had told me at the end of Friday, before we had all of our more explosive motions put before the court, that on the jail calls that might or might not come in with Mr. Copeland's testimony, y'all had maybe two items that you thought you could work out everything, and there were two items that were still kind of in dispute.
That may have been Ms. Hilton.
It might have been, I don't know.
Just to get him.
I was in and out a little bit on Friday, but did Mr. Steele not deal with the jail calls at the end of the day on Friday?
I mean, so what we ended up doing was saying, oh, we may be able to just come to agreement on everything. So give us a little minute over the weekend and we'll get back to you. Anyway, apparently nobody did it, but y'all do that
Yes, Your Honor.
tonight, if possible.
Yes, Your Honor.
Your Honor, may I be allowed to step outside the courtroom for a brief 5 or 7 minutes?
To line up Ms. Potter?
To line up Ms. Potter, and to speak with another member of our office.
Okay, so we will take another break and be back whenever you let a deputy know that you're ready, okay? Which hopefully won't be more than 10 minutes. All right.
Y'all have me so discombobulated. Like, Woody, I've been over here dying and talking about the pants. Like, oh my God, I did pull out the fan. I haven't bought this out in a really long time, but I've never laughed that hard on YouTube before. It's my fault because I talked about the trousers, right? Usually with trousers, they have a button on the back or they're stitched on the back. And that's how you could tell if they're a good fit. And honestly, I mean, we all know this as humans. If they're too tight, just size up a little bit. It's okay. Or get them tailored. Get them tailored. But you guys went in with the pants. And yes, I was muted, but that's how hard I was laughing. Like, I was legit. You wouldn't be able to hear anything they said in that courtroom. Like, every time I looked at a comment, because you guys will notice, like, for engagement, we'll pull up comments and things of the like, just to stay current with the chat. But you guys, I swear, like, our community is amazing. I have not laughed that hard in a long time. Somebody said, if the pants don't fit, you must have quit. That was probably the best one. That was probably the best one. So little moment of silliness. Let's get back. We're waiting right now for them to come back to the courtroom. The state has one more witness. Here's why I think we're entertaining this. We're severely behind for the day. And, you know, a lot of that, we had Melnick come in today. We had Kayla called to the stand unexpectedly, but she was at the courtroom. So why not? The judge called her up and was just like, hey, instead of he said, she said, we know that Kayla's here. Let's bring Kayla up on the stand. And Kayla has gone live and mentioned that she did not know that that was going to happen. And I think that could kind of be, you know, why we saw what we saw earlier. I'm not going to comment on that, but she has been able to tap in with the public and just let her know, you know, what happened with today's testimony. So that was interesting. Now, that took us past lunchtime. We were supposed to break, and you guys know Judge Whitaker is like sharp on her time. We were supposed to break at 12. I don't think we broke until like almost 1 p.m. So we came back around 2 p.m. and that's what we're watching right now. So because Melnick bought in these 5 emails, what the state is trying to do is they are bringing in their witnesses. We've seen a few employees from the state's office today, right? We saw 2 ADAs on the stand itself, which gives us vibes from the Alec Baldwin trial, right? It definitely gives us those vibes. Because when you start to see judges and prosecutors and attorneys on witness stands, you can tell the trial's going a little crazy. It's something might be happening over there. Like, I don't know. Is it law and order? What's happening over there? And that's what we've seen largely today. And it's just Monday. Here's why I think Judge Whitaker is a little irritated with the state. Their third witness is ready to be called, and apparently she's driving and is 30 minutes away. So they're trying to see if they can get her on a Zoom call instead, because if we're this behind, tomorrow we were supposed to have the jury and Lil Woody back on the stand. If we don't finish today on time, that might get delayed another day. So I think that's why Judge Whitaker is looking at ADA Love or DA Love, and she's like, hey, get them pants to walk in and get your witness here, because it would be nice to finish all of the things that we need to do today done on time. If not, then we're going to have to call her tomorrow and everything's going to just get pushed back. We don't want that to happen. So this trial is, of course, the dumpster fire that does not stop burning. Let me go to my supers and see where I left off. I think I left off right here. Shout out to Talking Trash and Truth. She gifted out some memberships. Thank you so much. And thank you for investing in this community. If you received one of those memberships from her, please tell her thank you. What I love about your picture too is it has a little cat with the T3. It reminds me of my AV7. Y'all see my little 7? I put that up yesterday all by myself. So I was really excited to see that. I think I got gas with the $10. I remember the Holiday Inn. Shout out to Jenny Cakes with the $4.99 super sticker. Thank you so much, Jenny. You see them? They had me laughing this entire time, Jenny. Like, I'm still kind of recovering from all that laughter, but you guys are amazingly funny. I think I even saw a troll in the chat that was like Judge Whitaker. So, this is a lot of fun for me. And guys, you guys know I love lead, but like, I love it here on my side too. Like, we could still cut up, have a really good time. But this community is just unlike any other that I've ever seen. So I love spending time with you guys. Y'all make it fun. Shout out to Scott A with 199 says they need to ask him his proximity to the attorneys. Scott, this was probably, I see you left this at 3:00. That was an hour and 37 minutes ago. So I forget what we're talking about here. My fault, brother. And if we could refresh our recollection, we totally would. So thank you so much, Scott. Really appreciate that. Shout out to Bilal, who became a new member. Welcome to the community, Bilal. You're going to love it here. Thank you. Thank you. Shout out to Night of the Nye with the 199, who says he sounds like Sherman Klump from the Nutty Professor. I haven't thought about the Nutty Professor in so long. It was one of my favorite movies growing up. Sherman Klump. Y'all are hilarious today. Shout out to Think and Grow Big TV with $2 says, was that Judge Glanville? No, he was not. He was not in the courtroom from what we could see today. There was a phone ringing at some point. Like, it's just, you can't make it up. You cannot make up the courtroom shenanigans. Like, her phone was ringing. Judge Whitaker had an office phone right there. It just started ringing. It just started ringing, like, out of nowhere. And she's like, I'm not going to answer it. I don't know what to do. It shouldn't be ringing. And this is not my courtroom. It's not my phone. So, you know, she did say that on the record too. We have been just watching all types of stuff go down in this courtroom today. Shout out to Stephanie, who became a member. Welcome, Steph. You're going to love it here. I love your glasses too. Did you go on vacation? Did you go on vacation, Steph? Let us know where you went. Shout out to Carl with the 10, who says, Love and Hilton, you're fired. You guys have been mentioning that you want more Trial Watch merch. I saw you're fired earlier, especially that you're like, you guys were like, spell it like how Woody would say it, like she fired. You want those shirts, you know, we will consider that for sure. Thank you, Carl, for the super. Shout out to Buddha Belly with the super sticker, $5. Thank you so much, Buddha Belly. It's good to see you today. Shout out to Blue Dream with 199 says it's hard to say goodbye to yesterday. I'm probably singing that wrong. I'm still discombobulated. I'm like Woody. I'm still discombobulated from all this. Like, oh my God, that laughing attack was real. I didn't know they existed. Like, Lead has had a few of them. That was probably my first laughing attack. Like, that was definitely my first laughing attack. Now I know what it feels like. Now I know. I've been broken in, so to speak. Shout out to Betty Spaghetti. Betty with the trays with the $19.99. She sends a super sticker. Good to see you, Betty. She is joining us a little bit later in the day. It's always good to see you on my side, Betty. Thank you so much. And I hope you are having a blessed day, sis. Shout out to Rob Lowe, $4.99. Super active in today's chat. No comment, no question. Pure love of the game. Thank you so much, Rob Lowe. Really appreciate you. Shout out to Trevelin. I could be saying this wrong. I hope I'm saying it right. Trevelin Gale. These are the €5 bucks. Look at that. So thanks, AV, for showing us new design of pants called Mendacity Distraction. Must get myself a pair. Guys, those pants took me out. You guys had me dying laughing. That was hilarious. If you're not a part of this chat and you're watching this on replay, I feel bad. I feel really bad because you should have been there. You missed it. You missed it. Shout out to No Weapon for Me. No weapon formed against me with $2 says, what do you think the judge's decision will be, AV? Well, she said a few interesting things today. Number one, she is taking Brady evidence seriously. So I think that she's actually really considering Max's motion. And I was reading this during the last break, guys, and we had to stop. But I did pull Max's motion from Friday that he filed right around 4:00. And, you know, a lot of people have been parsing through it over the weekend. I didn't, because a lot of it was more of the same stuff. But one thing that he had mentioned, he was talking about a list of all the egregious things that Judge Glanville did. And at one point, like, we thought it all started with Brian, like trying to, you know, toss Brian in jail for representing his client. We thought that, you know, some of it went back to when he was making attorneys write essays and things of the like. Well, it also looks like he was really coming after attorney Schardt too. You know, all the times he sided with the prosecution, we're seeing Judge Whitaker on a completely different level. She did not, if you guys were here for the first morning session, she did not give Adrian Love an opportunity to make a mistake. Like, she's just like, no, we're going to go back. You think you're going to get away with this thing? No, we're not going to do that. We absolutely aren't. So it's super, super interesting And great question, no weapon formed against me. But I think overall her decision today she's going to give Max a chance, I believe. I really do think that she's going to give him a chance to hear out the Brady evidence. If it was Glanville, you guys know it would have been like, I'll take it under advisement, put it under appeal, those sorts of things. Shout out to Ray, not Charles. Shout out to Cat, not Williams. Ray, not Charles has become a YouTube member. Welcome to the community, Ray. Really appreciate you. You're going to love it here. Speaking Now TV with $2 says Hilton stay out of the hot water. She's not in court today, guys. Often with the DA's office, you might have people that take a day off. They might have planned vacation. We have that, in corporate America. I know we refer to that as PTO, paid time off. That's like approved by your supervisors, and you take that time off from work, right? It's kind of like when you're in school, you have vacation time that's set. Hilton could have that time. Maybe she has a sick day. I've seen a lot of you guys throughout the day say that she's on vacation. I don't know if that's been verified, but she is not in the courtroom today. She is staying away from a crazy day, though. Like today has been eventful, to say the very least. Shout out to Paint and Sound with $4.99 says this judge going to rule just to get off the case. And I ain't mad at her. I mean, she might. Think about her demeanor last week. Super friendly, super happy, open to hearing both sides, calling it fair down the middle. Sometimes she gives wins to the defense. Sometimes she gives wins to the prosecution. All right. Now, today, as soon as court started, she said, she was like me. She was like, what do y'all want to do? I've been working all weekend. I ain't got time for this. She came in with a visual level of frustration that is not like what we seen last week. And everybody thinks she's doing a stellar job compared to Judge Glanville. She's doing very well, right? But she came in really frustrated. She was not going to allow people to ask questions, to the point where today, when Kayla was on the stand, to get clarity, did you guys see that Judge Whitaker started saying things like, let me ask her instead of the defense attorney? She was just like, Kayla, here's my question. Answer it clearly. Answer the question. Answer the question. She is very frustrated today, guys. I think that we're behind on time, and she does not want that to happen. So Paint and Sound, you might actually see that take place. Shout out to HVM, the other HVM, with $9.99, and he types respect. Guys, also became the other stream sponsor. Whitney is a current stream sponsor, but I got to start naming y'all because we call you both HVM. This is the other HVM. So if y'all could do me a favor, and I don't want to say HVM2. How about we type in OG HVM in the chat? OG HVM, because there's two of you guys. And it's really because one changed his username, but we're going to give this the OG HVM. If y'all could type OG HVM in the chat, that would mean so much to me. Thank you so much, OG HVM, for coming over to my side. I don't see you over here that often, so it really means a lot that you're over here. Lead is out for the day, so I am holding it down, but it's just so great to see, pillars of our community come over on this side. And look at that. Look, I've created a new name for you. OG HVM is over here, and he says respect. OG HVM, I have so much respect for attorneys that do this trial work, as I am getting ready for the bar and doing all this. And guys, I just moved last weekend. This whole weekend, I've been putting these bookcases together, like doing all this stuff. I had to take a little bit of a break from giving my editors some production direction because I wanted to get ready for today. And boy, oh boy, it's just been a crazy day. But when people support me like this, it just means the world, like Lead and I go through it. Like sometimes we're not having great days, but we're here to really show up to these trials and explain the context from a legal perspective. I like to do it from a production standpoint too, in a short and sweet, easy manner, because stuff like this happens where we will watch the trial, but look at how much time is wasted. Look at how much comfort breaks took place with the last judge. Look at what's happening here. You have a prosecution's office that doesn't have their stuff together, and it's time to peel back the layers of the onion and see what's really going on there. to the point where Donald Trump this morning is talking to the young people. And it's like, oh, did y'all see what's happening to King Slime? Hold on, let me tell you what's happening to King Slime. It's not fair, and it's happening to me. Did you know that it's the same DA's office? They're doing it to him, and they've done it to me. It's really interesting. You know those RICO charges, those bogus fake RICO charges. Fannie Willis and team are doing this all the time. They do it to everyone. They're doing it to Young Slime, Young Thug, YSL. It looks like we're back, guys. HBM, I'm over here bugging today, but I hope you enjoyed that.
Were you able to get?
And I'm going to add you to the banner.
Ms. Potter?
So Judge, my request is that the court allow us, if I call her, to do it in the morning, and to also allow us to, because we've got the case that.
Hang on.
Oh.
Sorry, they said we're ready. So I just kind of assumed we were ready. Hang on.
Oh, we're not ready.
I should have looked. There are some empty chairs.
Oh, everybody's not back yet, guys. They're waiting for some of the defendants that are not back in the courtroom. But it looks like Love is trying to push this to tomorrow. What did I mention? We can see that. You know, if she's pushing it to tomorrow, that means we may or may not see Lil Woody on the stand. I hope that, you know, if this is their last person, that we still get to see Lil Woody back tomorrow. But here's why this is a big deal. We have to let the jurors know today if they're expected in court tomorrow. They do have notice where they need to be within a certain arm's length reach of the courtroom. So if they are needed, that they come back. And a lot of times when they're selected, they will need to live in close proximity to the courtroom. But these are just some things that we need to consider, because if we're going to make that call tonight, they need that call tonight. Instead of, we might push it back again. Because right now, this court has not had this jury in this courtroom or courthouse in almost a month and a half. We have not had them for the entire month of July. We had them leave, I think it was early June, and we haven't seen them since, right? The attorneys have been going back and forth on some of this small stuff, but all this other stuff is happening on the back end. So it's really interesting because it is very likely, and I really want to go to one of our stream sponsors. I want to go to Thinking from Texas, Whitney, who made this comment earlier, and I forgot to bring it up when you made it, Whitney. Whitney just dropped another $100 super, okay? And Whitney had already dropped $250 for today's stream, and she's just like, OG Adrian, I see you, but I'm not losing my spot. So Whitney is now at $350. But here's the other thing. Whitney had made a...
That's everybody all right.
Hold on, guys. Whitney had made an excellent comment, and I'm just going to pause it. We will be a few seconds behind. And that comment was this. It was, there's no way that this jury has not seen this already. Like, out of all of them. Have they run into any media talking about this case, and they've been gone for a month and a half? They've been on summer vacation. Summer vacation. What does Whitney say? She says, I cannot approve of the Trump interpretation. I'm dead. That was... Thank you, Whitney. If y'all could put Whitney in the chat. That was me. Like, I'm getting silly. Towards the end of the day, I get silly. My coffee has worn off a long time ago. So if y'all could continue to type in Whitney in the chat, we have amazing stream sponsors today. Whitney is on top. We have OG HVM. We have HVM. And of course, we have the Little Gaming Channel, who's on the West Coast and has been with us all day. You guys are amazing. Thank you both for your super chats. But let's get back to court and see what they have to say.
Thank you, Judge. The state is asking if the court will allow us an opportunity to respond to the Ford Motor Company case that we provided today, and in making our final argument, and to allow us, if we decide the need to call 88 Potter. The main thing that I wanted to get out was regarding when Mr. Copeland pled, and I haven't had an opportunity to talk to her about that. I think she was the one that represented the state in that plea.
Yeah, she was, but I mean, I told you that he pled on June 28th of 2023.
Right. When I first started looking at Abigail Potter and had the 3 names.
Oh, okay. So you may not need her after all, then
You know?
that's fine. Yeah, if that's all you needed her for, it's in the court record.
Okay.
And I have taken judicial notice of it. And then a response to the Ford case, I mean, with regard to whether that's the law or not, or whether that's an appropriate
I have not.
sanction. Yeah, yeah, sure. You haven't had a chance to take a look at it, sure. Is that what you're saying?
Yes.
Yes, that's fine. You can make whatever response, if any, you want to in the morning.
And thank you. So that's it.
Okay.
Outside of Ms. Potter, I don't think that we would have any other persons to present, but if we did, we would have them here and ready to go first thing. I just wanted to review all of our notes and make certain that every issue that was raised here today is addressed properly.
That's fine.
Thank you.
And Ms. Rosser's looking for that certificate of service of the subpoena. And
I know that we keep copies, so I can get one of those too.
So it looks like Potter is not going to testify. They actually didn't need it. And it's kind of like, why did you even present it? Why did you tell us you needed her testimony if we don't really need it? But it looks like the other things that were mentioned in court today is a reason to suffice needing her in court. So it looks like she's talking to her assistant, coming back to the mic now.
I think that I've got the certificate of service of a subpoena that you are referencing, because it has that on May 31st, Investigator Long actually served Mr. Copeland, and I'll let you look at it, but it looks like it actually is also attached as a, and I don't know if it was or not, but it at least references that the order that Judge Glanville enters on the 7th that is pursuant to 24-5-507 that gives him immunity, maybe attaches that subpoena, but I don't know. Anyway, if you want to come take a look and see whether that's what you mean. And if so, we can make a copy of it and you can do whatever you want with it from there.
It looks like we have a copy of the document that went to Woody when he was served. We'll see that why that is relevant.
Okay.
Is that it?
It is. It is. It's attached to the, as the court said, it's attached to the motion to, well, the order granting the state's motion to compel.
All right. And so it's already, I would think, then in the record.
Yes. Yes.
All right. And so what's their argument you wanted to make about that? Or just?
Just that, and I can reserve the rest of it for tomorrow, but just that he was served, Mr. Copeland was served on May 31st, and I think that's well a week before he was ever called to testify or anyone was informed that he would be the next person up. And we did not, I'll make argument at the appropriate time.
All right. Okay, so tomorrow, in addition to wrapping up whatever final evidence and argument there might be as to either of those issues, what I would like, I think y'all now have, if not every bit of Mr. Copeland's prior testimony, almost every bit of it, and Ms. Weaver's been pretty fast at turning it around. And at this point, it may be best to redo the entirety of Mr.
Ooh,
Copeland's
Whitney gotta
testimony,
start over.
including bringing him back in and asking him whether he wants to testify.
Woody's coming back.
And I'll hear from everybody on what we might need to advise him of, if anything. He's been, or we advise him of, or correctly advise him of, and then just maybe
We're
start from
starting.
scratch with
Oh.
him. If there are things that everybody can agree, I just don't know whether we know what he's going to do or how he's going to testify. So I don't know if it's productive to continue to look and see whether there are things y'all can agree on.
Wow.
But if there are things that everybody can agree on and we can just say, okay, you know, these 5 things take as, you know, something he said and the rest of it redo, or whether we just want to start 100% from scratch. As I understand it, nobody had played the June 10th, 2015 interview from him yet anyway, right?
That's correct.
Okay, and that's the only one where he inculpates any of these defendants, right?
No.
No, that's not right. That in the Donovan Thomas murder is what I mean.
Oh. That's the first one, yeah.
Okay. All right.
It was directly in the way that he did on.
Okay. Okay. All right. But we need to make some progress into the, I mean, I am still considering in working through Mr. Schardt's motion, and then we'll get to Mr. Weinstein's motion for mistrial. Both of them are motions for mistrial.
Wow.
But assuming for the purposes of getting things done, that those are not ultimately granted, then we need to pick back up with this trial. Obviously, if they're granted, then that's a whole other ballgame. But I want us to make progress in the meantime. So tomorrow, I would like for our focus to be on how to handle Mr. Cohen and his testimony or potential testimony once we have the jury back, whether there's any agreement as to anything, proposed jury instruction as to if we're disregarding any or all of it, what that should say, whether we need to take notes, all of that kind of like the details we actually need to think through.
Wow.
I want y'all working on that tonight so that we can make progress with that tomorrow. And, you know, there are a lot of things up in the air in this case. And I am going to once again say to everybody that there's a lot of risk for everybody. There's a lot on the line for everybody, both sides of this case. And I know not everybody has necessarily the most fruitful relationship with each other across the aisle right now. But I know, Mr. Steele, you said that you do still have a good relationship with the district attorney herself, who certainly authorized to talk about each and every case because they're all her cases ultimately. But, you know, y'all need to be thinking about all of the potential ways to handle and move forward in this case. And I encourage y'all to be doing that because who knows what it's going to be otherwise, okay?
Wow.
We did get last night, speaking of things that we can deal with.
Yeah.
We got last night from Mr. Schardt, and he can correct me if I'm wrong, I believe about 76 proposed redactions from the proper of one of our witnesses that we discussed on Friday, Mr. Zachary.
Okay.
At some point, I know that the court is going to have us to address those. So And I believe that Mr. Schardt, he can again, correct me if I'm wrong, said
Mm-hmm.
that he could go through that was what, the August 2017 interview, a proffer from Mr. Zachary. And there's an earlier one that I think he said he's gonna go through and. Okay, he said he's gonna go through another one.
Okay.
And so if he sends us those, that's another thing that we need to work out.
Perfect. And so y'all go ahead and tackle the first 76, see if there are things that you can agree on so that we can have an efficient day like we did on Friday, where we sort out so that everybody knows here's what can and cannot come in potentially with regard to this witness. And he's coming up pretty soon. And if Mr. Copeland makes a decision different than his last decision, we may be getting to Mr. Zachary sooner than we think.
And
Wow.
if that is the case, then the state would have a motion for the court, similar to the one prior, with respect to Mr. Cole.
You're gonna have to give me a hint as to what you mean by that.
So John just now did a reference if Mr. Copeland chooses to do something different than what he chose to do last time.
Uh-huh.
with respect to testifying. I'm assuming the court needs to plead the fifth again. I don't know.
Well, I mean, I'm not undoing the immunity order. The immunity order stands. Unless y'all got some, I mean,
That's what I was.
Okay. All right, well, I mean, I guess we can, I don't at this point see a need to undo and potentially redo an immunity order. I know that there is the argument about how paragraph 11 might contain a misrepresentation as to whether there was an encounter. I mean, the way I read it and what it says is there was an encounter with representatives of the DA's office and people from the defense team. After that, Mr. Copeland told somebody he might plead the fifth. Now, I don't know whether from that it means Mr. Copeland was even a part of that encounter, or if that's just given me some kind of a timeline about one thing happened and then another thing happened. But the import of that to the predecessor judge and to any judge considering does immunity need to be granted and is immunity in the public interest here is not what triggered it. It's this witness who the state thought was going to be testifying voluntarily under subpoena or not, now intends to take the fifth. The only way we can get their testimony, which we believe we need, is to compel it. Will you compel their testimony? That's the import of it to me, not what led up to it, because there's no allegation of coercion or dirty dealing or anything like that, if it even means that Mr. Copeland was involved in any of that. So I don't believe that the immunity order needs to be redone. If somebody else thinks differently, y'all let me know that right now. Silence. Mr. Steele.
I don't believe anything before Mr. Weinstein filed the first motion to recuse. I'm not challenging anything before that.
Okay.
But I do want to hold, there was a lot of exculpatory information before the recusal motion was filed, so I don't want to wipe out Mr. Copeland's testimony on
Okay.
the 10th,
All right.
We don't want to do it.
part of the
All right, which is why I need y'all to get together on it and let's tackle that tomorrow,
Okay.
the nitty gritty of it. Okay. All right. So that means y'all have to do that tonight if you haven't already done it. All right. Anything else before we break for the evening?
No.
One more thing.
Wow, guys. So it appears that instead the judge suggested that we could start over with Lil Woody's testimony. That would be a
So it's my
disaster.
understanding that other than the transcript of June 12th, everybody should at this point have all of the testimony of Mr. Copeland, and the transcript from the 12th should be forthcoming within hours. And, you know, Miss Weaver was working at like midnight last night. So as soon as she gets it, she'll either forward it to Ms. Percival, who forwarded it to you, or she'll forward it directly. So y'all should have that very shortly.
It doesn't look like Brian wants to start over with Woody because he's got some gold.
All right, anything
possible
else
to him
before I
anymore.
bid y'all adieu for the day?
May I inquire if it's appropriate? Is the court's plan to bring the jurors back in on Wednesday? Is that still the plan?
Uh-oh.
I
Uh-oh.
don't know, because we got things done today, but we didn't get any
They're behind.
evidentiary.
They're behind.
Make any evidentiary progress today. So I don't know. It's less likely now than it was on Friday. And I'll just let y'all know right now that I have an appointment that was set up well before I had any involvement in this case for Friday morning. So I am not available this Friday morning regardless, this coming Friday morning. And I'm not gonna, I don't know. Let's just see how tomorrow goes. I think we'll have a much better idea tomorrow, whether it's Wednesday for 2 days, which I don't love, or whether it's just next Monday, and let's actually make lots and lots of progress in the next few days and then buckle down with a trial on Monday if it turns out being that. But I'll, remind me tomorrow to think about that again. All right. We're adjourned for the day.
There it is, guys. There it is. Wow. What a action-packed day in court. What did the judge just say? The focus of tomorrow. So Woody was supposed to be back today. It got pushed back. And then they moved it back to Wednesday. And she was just asked, thank God Max asked her that question before court ended. He's like, is the plan still to have him and the jury back on Wednesday? Are we going to do that? And she said, deep exhale, I don't know. She has an appointment on Friday. So if we do bring Woody back on Wednesday and Thursday, tomorrow, the entire day is dedicated just to figuring out how we're going to handle Woody on the stand. Brian does not want to start over. The judge suggested that one of the options is to start over with him fresh. This all of last week, the reason why we had to go through the jail phone calls, the interrogation footage, and all of that. And remember, the only reason why we're doing it is because Lil Woody was not cooperative on the stand. This month-and-a-half delay has been because of the ex parte meeting, but also because Lil Woody has not been cooperative on the stand. You guys let me know. He just put a song out called I Don't Recall. Lil Woody eating, okay? And if he comes back on the stand, they have to anticipate how they're going to handle some of these things. How are we going to handle the fact that it is likely that if Simone questions him, or even if it's Love this time? Can y'all imagine if it's Love? If Simone is on vacation and if Love has to question him, I hope she just got the day off. Can you imagine if Love is questioning Lil Woody? And how is he going to work with her to get some of these answers out? It's going to take a while. Simone really struggled getting through that direct examination. She was asking him poor questions. And, when the ex parte meeting transcript came out, we realized why Lil Woody was being combative. We realized that, hey, it looks like he was being set up. She also just said, I don't know if you guys caught that about 20 minutes ago, when he was served saying that he was going to have to be on the witness stand, it was May 31st. And he was there a week later. That's also an interesting piece of information that I don't think any of you guys, or some of you did pick up on it. I did see that in chat. But that is interesting. So Lil Woody didn't have a lot of notice leading up to this. He was a represented person. We spent the entire day going through Melnick's testimony. We spent the entire day going through Kayla's testimony. And now this man is, it's time for him to come back. So what do? We're going to have to put up guardrails and anticipate if he is not cooperative, what is the next step? The good news is that they did take all this time to develop a transcript, both for the jail phone calls and for the videos the interrogation video. So if he is uncooperative, they now have all of that typed up. It should have been done beforehand. But I really do think that the state had no idea that he was going to do this to them, putting himself in danger, so to speak, as well. You know, sorry, guys, I have neighbors that are wicked loud. But anywho, that's what we're expecting. The entire day tomorrow is going to be looking at how we're going to handle his testimony and planning for it. Lil Woody can't come back and give testimony unless the jury's back. So that's why that question on when is the jury coming back it's an important question. Are they coming back Wednesday? And she said, Judge Whitaker said she doesn't like having a two days of worth of testimony because it's better for the jury to start like Monday through Friday. So we'll see. I mean, right now it's not looking good. It's not looking good, but no promises. She did say it depends on how quickly we get through this tomorrow. I don't think that Brian is going to be the only defense attorney that doesn't want to start over, because here's why Brian doesn't want to start over completely. Lil Woody said a lot of stuff in those interrogation videos and in those jail phone calls that they could use. And it is likely, as they were going through the evidence, it's likely that Brian and some of the other defense lawyers are starting to get their questions ready for Woody. Because here's the thing, Woody can be difficult up there with the prosecution side, but those defense attorneys are going to ask him questions. I think at one point they even said like, hey man, you might get hammered up there. And I don't know if y'all could hear that, but my neighbor upstairs is vacuuming, so directly above me. So I apologize for that noise. All right, let's clear out a few supers, and then we'll keep it moving for the night. Again, shout out to Thinking from Texas, Whitney, your stream sponsor today. And yeah, you guys missed a bunch of shenanigans. You missed my Trump impersonation and all of those things. Shout out to High Value Man, who said respect as well. OG HVM. Shout out to Digital Pocket Change with the $4.99, says, I think the judge wants to hear as much as she can before she makes her decision on the motions for mistrial. And here's the thing. In addition to figuring out how we're going to handle Woody, tomorrow we have two major motions. One is the Max Schardt motion that I showed you guys a little bit of. Ultimately, what that is the Brady material. Should this case be dismissed based off of the Brady material? So you have that. The other one is Weinstein's motion for a mistrial. She still hasn't ruled on that. Those two are still outstanding. If she grants a motion for a mistrial or dismisses the case because of a Brady violation, which again, Alec Baldwin, keep that back here. The nation is looking at how judges are ruling on these type of things. If she grants it, then maybe we never see Woody again. Who knows? But these are major decisions that are still going to be decided upon this week. So I think it's just getting started. I think it is literally just getting started. Shout out to Marie with $19.99, says, I love this channel. I'm a paralegal at home, and the way you break it down in layman's terms is spot on perfection. Thank you so much, Marie. I try. Like this morning, my hair was all done, and you know, by the time we came back in the afternoon, I said, throw a braid over here, it's getting sweated out. You know, they got me laughing and tears, sweating over here with the whole pants thing that I started. So, you know, I appreciate that you like the legal commentary too, but this community is just so rad. I love it so much. We have so much fun over here. Shout out to Drew Beats with the 5, says Woody is not going to testify again. He'll plead the 5th. That's the other thing. Did you guys catch that? The judge did say that if even with immunity, he could plead the 5th again. So this might be a carousel of a dumpster fire all over again. We might see the same shit. Sorry, because I'm getting frustrated. The same shit that we saw before could happen again. I'm literally just going to call this a dumpster fire trial. Like, what else do we call it? What else do we call it? This is such a shit show. It's just so bad. Shout out to Layla with $1.99. Thank you, Layla. She says she has her wax appointment Friday. Oh, Layla. Layla getting real. She's talking about the Brazilians now. Let me come to a few of you guys on the Cash App side, and I'll be honest, I'm starting to get a little exhausted over here myself. I have not read this since 2. So if you sent to Cash App, guys, I'm catching up right now, with the exception of the Venmo that Whitney sent. Shout out to Beth in Seattle with 10. She says, my YSL fix. Much love and thank you. Sorry, guys. One of my friends got on me. It was just like, can you please stop slapping your arm and denoting narcotics as you're talking about your YSL fix? I was like, yes, thank you. I will stop slapping my arm. I realize it doesn't look the best, right? So thank you so much for that one. Shout out to Drew Beats again with the $3, says, I was at the doctor. What I missed? Well, it looks like you're all caught up because you're caught up over here. So it looks like you are all caught up, sir. Thank you so much for tapping in on the Cash App side. Shout out to Talina with the 5, says, great job, AV. I'm in the chat as TT. Oh, well, thank you, TT. I appreciate you, sis. And thank you for tapping in on the Cash App side. Shout out to Steph Russell with $2.99. No comment, no question, pure love of the game. Thank you, Steph. Shout out to Dylan with the 5. And he says it's over for the state. I mean, where do y'all want to start? How much have we gotten through today? They can't find witnesses. You got the other DAs on the stand. Like, I don't even know what the purpose of her bringing up her work colleagues was. To dispute what Melnick was saying? How do you dispute that? The emails are going to speak for themselves. And then it's like, y'all remember this morning? She was just like, oh, is that the complete email? And it's just like, no, I'm not responsible for Brian Steele's, staff putting it together. And she's like, what's it missing? He's like, your email signature. Is that enough? Do y'all remember that meme with that chick that goes like, like, is that enough? I don't know if it is. Shout out to Bill Boyles. Will sends $5, says, next witness, Sergeant Solch. He knows nothing. Interesting. Shout out to Angie. She sends me $5. She says, thank you for the commentary. Thank you, Angie, for watching. So appreciate that. It's so funny, guys. There was a point where I was laughing and I got an email that says, and they were talking about Lil Woody starting over. I got an email that says, welcome to Mercury retrograde. I was like, that is too funny timing. Shout out to Liz, who sends $1. She says, judge is collecting even enough evidence for mistrial. I think she is. Judge Whitaker actually had amazing performance today. I think that she comes off as being nice, but she will lay the hammer on you if you're not careful. We saw a lot of examples of that. So Liz, thank you so much for that observation and for the Cash App. And then shout out to Yolanda with $5. She says, love you and lead attorney law info. I'm glad you guys you enjoy watching us. Well, it looks like my neighbor has concluded their vacuuming session. I'm going to run out of here. I've caught up on the Cash App side and on the Super Chat side. You guys have been blessing me all day. I've done a full 8-9 hours, full trial. Lead and I will be back tomorrow. So we've been texting throughout the day and just kind of game planning some of these things. He's tapped into the chat today, couldn't be here today. So that's why I held it down solo, but I cannot wait to tap in with you guys tomorrow. Make sure that you like, comment, and subscribe. Feel free to let me know your thoughts of all of today's shenanigans in both sessions videos. If you saw this morning's, if you're just tapping in now, please watch this morning session because it is full of the tea. And if you are tapping in the afternoon, let me know what your thoughts on this entire trial are. If you have any questions about it, things of the like, we're always in our comment section. Even if you don't get a response, we're looking at it for data points and see how generally people are feeling about this case, right? And that helps me and my team create amazing content. Members, I'm going to post tonight. I don't recall all of these shirts, and What You Mean will be on sale for my members. I think that's just a level of appreciation for you guys investing in me and my channel. So you'll see that. At some point, I'll get to my editors to get into some of these minute legal things and give you guys a synopsis of that. So they're waiting on me. They're like, AV, we're ready to edit. What are we doing? But they're waiting on me, So I will get to them and we will be dropping some supplemental material for you guys throughout the week. Thank you guys so much for watching. Stay safe out there. See you in the next one. And huge shout out to Thinking from Texas, Whitney, who is your stream sponsor. Court is adjourned until tomorrow. See you guys then. Bye.